Beautiful friends. I just pressed the Let's Go Live button, so that means we've got to wait for the stream to fire up all across the fruited plain of the interwebs. Before we go ahead and get started, got to make sure those tubes are connected. Sometimes they're not connected, and that's a problem for us here. But it looks like they are alive. They are working. That's tremendous. We're on Rumble. We're on Locals. We are on YouTube. We're on Telegram. And it looks like it's connected. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about Fani Willis and Georgia. My goodness, things are getting very spicy out of Fulton County. We've got two things we're going to talk about today. The first is going to be a massive monster supplemental that came out from defense attorney Ashley Merchant, who is the attorney representing Mike Roman, who submitted the big whopper originally to kick this whole thing off. The attorney who wants Fani disqualified and wants the indictments dismissed. Of course, the Trump prosecution's 19 co-defendants. We're talking about the Nathan Wade, the Fani Willis affair saga, all going on. And we're going to go through this 66-page supplemental because what Fani said is we don't need to have a hearing on all this stuff. And she said, here's an affidavit from Nathan Wade, and here it explains everything. It has everything that you need to know there, Judge. And then Merchant and Roman, the defense team, they submitted this puppy back and they say, Judge, look, this is why we need to have a hearing. These are the witnesses we're going to present, and it's just going to be an absolute doozy. So we're going to read through it and see what is happening there. We also got news. Fani apparently has been served by the U.S. Marshals, so she rejected Jim Jordan's subpoena, said, I'm not going to accept that, made the Marshals serve her. They've also got outside lawyers, apparently, that are working on her case, and it is interesting why they can't handle it within their own county. Strange. But then also some Georgia senators are reviewing her. And so 11 Alive out of Atlanta, they're explaining what is happening out there in the political sphere as well. But today, we also had this hearing. I wasn't sure what's going to be happening today, but it was one on a motions hearing that the judge submitted just last week on Friday, said that there was going to be a hearing today to talk about the motions to quash because Fani, she got a subpoena to show up on Thursday, the day after Valentine's Day. Isn't that fun? And she got an order to show up. She tried to quash it to say, don't you know who I am? I'm Fani Willis. I'm the biggest Fani in Fulton County, and I'm the DA, so you can't just, come subpoena me. Who do you think you are? And so what happened at the hearing today was juicy as well. The hearing is on. It's going to be scheduled for Thursday. The judge says, look, there's enough here. I at least have to hear it. I can't get rid of it. It's not something that is dismissible now. So the the motions to quash have been denied. The subpoenas are still active, but there's just a little bit of a procedural hurdle that they need to go through in order to get Fani on deck. So we're going to explain what is happening there. We're going to go through the hearing. We're going to listen to it at 1.25 speed. We got a lot to get through. And so we'll hear it and see what's happening all today. It's a lot of Fani news out there. And we're keeping our eyes on a couple other things out there. So we're keeping our eye on a Trump Supreme Court brief, if he's going to be petitioning the Supreme Court for a writ of certiorari. Waiting for that. Haven't seen that one come across yet today, but that could drop any minute. We will talk about that tomorrow if it does drop, or it may not drop. Maybe they're going to send this back down to Judge Chutkan. We'll see. We're also waiting for Engoron's ruling. Mid-February is when Engoron from New York is supposed to talk about whether he's going to strip Trump of his businesses. And so we're waiting on that one as well. And so we've got going to have a busy week ahead of us, my friends. Hopefully you are subscribed and joining us wherever it is you're joining us. This morning, we had a great conversation during our members only stream. We already had a full stream this morning, if you didn't know that, but it was awesome. We talked about, we're really getting into our election coverage. So if you're interested in the 2024 election, we spent a lot of that time on that this morning, and it's just getting spicier and spicier. Kamala apparently is ready to serve. We talked about Newsom. We talked about Michelle Obama. Sounds like maybe she is not going to be running because she hates politics and probably herself. But, there's a lot to talk about. 2024 stuff. We really spent some time on that this morning. Watchingthewatchers.locals.com. Members only streams in the morning, members only streams on Saturday, and after parties after the show is done here. We have an awesome community, so come and join us. We've also got our website, robertgovea.com, which is where you can get all the PDFs. Got one PDF on the docket today, so that will be up online at robertgovea.com if you want to download that, read the reports, buy some gear, grab a hat, grab a shirt, support the show, and look good while you're doing it. And also, very excited, so we've got Watcher Lodge, which is our sovereignty and self-development portal. And this week, we've got a really fun event coming up. It's free for everybody to come and join us. On Friday, we're going to be doing a political Zen wellness masterclass with this guy called Jason Campbell. He's awesome. I've known him for years. He teaches you how to breathe, how to think, how to calm some of that mental turbidity. And so I invited him on to our new lodge to come and just share with us, his Zen wellness. He's a master. He's a black belt. He's a musician. He's a sheriff of a town here in Arizona called Cleator. He's awesome. He's a lot of fun to listen to. A lot of ancient knowledge. And so come and join us. WatcherLodge.com. Totally free. It's Friday, 9 a.m. my time, 11 a.m. Eastern time. But you got to go and register for it because it's going to be a Zoom link. We're going to do some breathing and some exercises. And so come check it out. WatcherLodge.com. And if you're out there, if you're like, Rob, Zen wellness, you want me to get into Zen wellness? Like, who do you think you're talking to here? Don't you know who I am? Well, it's, yeah, I do, because that's kind of how I sounded. But it's good, right? If that's kind of how you're feeling, you probably need it more than anybody, talking to myself. So that's how I was, but I love Jason, man. He's awesome. WatcherLodge.com is where you can come and join us. And we had a lot of fun at Watcher Lodge this weekend, by the way. We unboxed this puppy. I almost forgot to mention this. We unboxed the SDS 200. Ooh, yeah, baby. So we did a full unboxing. You can check it out. It's scanning all the police stations right now. Mesa, Gilbert right now. We might have something going on. Here, let's listen. Oh, it's scanning again. Of course it did. So here, let's see if it picks up anything. Arizona Wireless, Thompson Peak. It's scanning all the different, police, fire, and so on. We unboxed the full thing. It's scanning away right now. We had a lot of fun. So it's still available if you want to go check that out. WatcherLodge.com. You can watch that. And you can still get your emergency management plan template over there, and your survival squad course is over there as well. WatcherLodge.com. All right, anyways. Now, let's get to it, my friends, because we've got some Fani business to attend to. We got some serious motions to talk about. So let's get to it, shall we? Fani Willis exposed. We have a 66-page supplemental filing from defense attorney extraordinaire Ashley Merchant. And this comes on the heels of a request from Fani to cancel the hearing. Fani said, we don't need to talk about our love affair, her and Nathan Wade's. But Judge McAfee said differently. And we're going to hear from him later on in a separate segment because the hearing is on. And he referenced this supplemental, saying that this is some of the stuff that they're going to be talking about when Fani is back in court on Thursday. But we're going to see what is inside the supplemental, which really sheds some light, adds some details, adds some meat on the bone to this whole saga before we get reaction from elsewhere around Fulton County. But this is the filing. The case is the state of Georgia versus Michael Roman. But remember, Michael Roman is one of 19 other co-defendants. 4 co-defendants in Fulton County, the RICO case in Georgia, have already pleaded guilty, and this case is still moving forward. The hearing is scheduled for Thursday, the day after Valentine's Day, very apropos for our friends Nathan and Fani. So they're going to, be having probably a pretty tense Valentine's Day dinner, and then they're in court the next day. Oops. So state of Georgia, and this is the response from defendant Michael Roman. And his attorney is Ashley Merchant. And you'll just notice at the top of this PDF on your screens, my friends, 122 pages. Woo! That's what we're talking about, right? That is a nice, hefty filing. And it's from Ashley Merchant. And let me just give you just a preview. Sorry to blank your screen out there. But here you can see lots of stuff as exhibits and as addendums. We're going to read the motion, but I just want to show you what it's referencing. So when they reference it, we know what they're talking about. This is a business record certification. We've also got some Vacation Express numbers here. We've got Nathan Wade transaction approved for, $3,800. Man, $3,800. Yeah, that's a pretty nice one. And all this is for the cruises, right? The Cruise Authority. Vacation Express. Guess who's here on American Airlines? Oops, there's Fani. There's Nathan. The Cruise Authority. Hyatt Regency Aruba and Casino. Are they gambling on Fulton County taxpayer dime? Vacation Express, right? All this stuff. It's all included. It just keeps coming out. They got the insurance plan. Oh, no, they didn't. They declined insurance. They're like, what are you, nuts? We're going. Like, what's going to happen? Who's going to stop us? We're Fani and Nathan, right? So they don't need insurance. Get out of here with your insurance. So here's Ashley Merchant, and she's sending a bunch of emails back and forth, travel documents, and she's just got it all. Airfare information, right? All this stuff, Vacation Express. She's just digging into it. Here's some more travel documents. Wow, this looks nice. 3 nights accommodation, 1 king resort with an ocean view room. Isn't that just perfect? A European plan. Oh, that's nice, Fani. Hope you guys enjoyed it. Hyatt Regency in Aruba, in Dutch Caribbean, Aruba. That's real nice. As all these co-defendants are being prosecuted by your office, you're getting paid for that and sending it over to Nathan Wade, and then he is taking you on these cruises. So here's some more documents, right? Here's a cruise statement, and these are new. We haven't seen these before. So cruise package, here's the Ship of the Seas. It's 4B, category 4B, which is a spacious ocean view balcony. And yeah, it might be an upgraded cabin. You never know. It leaves Miami. It goes, it debarks in Miami, embarks and debarks. So, full circle, comes on back. Look at these 2 names of the passengers. Wow, Nathan Wade and Fani Willis. Isn't that fun? $1,300. So, $429 for 2 passengers. And yeah, it looks like a good deal. $500 a ticket for a 3-day cruise, not too bad. So then they got to fly out of there. It's out of Miami. They got to fly from Georgia. And so here, it looks like more arrivals and departures. All the cruise numbers. Here's another cruise statement, maybe the same one. Passenger Miss Clara Bowman is someone else who's joining them, I guess. Maybe somebody's mom or something. But okay, so this is all the addendums, right? These are all the appendices, the exhibits, and so on. And so let's get right into it. So we know what they're referencing. We know what is coming. Here's the filing. From Ashley Merchant and Defendant Michael Roman, moving to disqualify Fani Willis and to dismiss this case, the RICO indictment brought by Fani against Donald Trump and 18 other co-defendants, says comes now, Michael Roman, and we now move to dismiss and disqualify Fani. Why? We need an evidentiary hearing, and as grounds, we've got the following things that we want to introduce to you. Here we start. They say, Your Honor, Judge McAfee, this court is faced with a monumental and historic task, deciding whether to disqualify Fani Willis, the elected DA, which is a huge position, right? I can't underemphasize this enough. The county attorney for the biggest county in Georgia is a big position. You're a county attorney in your most populous city anywhere, county anywhere. It's a big position. Hundreds of people, a lot of money, okay? Very, very powerful. Some people say it's like top 5 in a city, right? Maybe like right behind the governor. So it's big. Elected district attorney in a case involving the prosecution of a former president. It's wild. Now, this is unprecedented, they say. We are in uncharted waters. Roman, the defendant, understands that this is not an easy decision. Now, particularly given that this is an election year and we are living in a politically charged and a polarized time. Nonetheless, neither Mr. Roman nor the court has put us in this position. Okay, we're not responsible for this. Fani Willis has. And the important role and the function of the judiciary is to protect integrity, sanctity, and fairness in this process. Now, aside from the Constitution, this court and the rules it applies here are the principal guardrails to ensure that the judicial process in our democracy is fair and transparent. Now, our legal system was designed to ensure that before we get a verdict, that the defendant stands as an innocent man. You remember the presumption of innocence that we forgot about in this country? And the state has an obligation through a disinterested prosecutor to seek justice, not just a conviction. But when the lines get blurred between a prosecutor's, in this case Fani's, between her personal fame and her publicity and her public duty, well, the system breaks down, as does the public's confidence in the entire process itself. They say, Your Honor, the right to a fair trial is not trivial. It was not an afterthought or a catchphrase. It was rooted in the Sixth Amendment, made part of the Bill of Rights, which meant the founders knew it was pretty dang important. The founders also knew that to deprive a defendant of fairness in the criminal process would deny him of a right to a fair trial. And so we put those in there explicitly. We put them in the 4th, the 5th, and the 14th Amendments, which incorporated the lower level amendments. Now, in other words, the several individual rights of the founders believed they were necessary to a functioning democracy. That's why we have them. Now, especially in this case, these principles are even more important. Now, it matters not that this case is under a national and media microscope or that this case may garner any more attention. In light of the attention this case was expected to garner amongst the public, they had an obligation. They knew it was going to be a big deal, and they should have protected this even harder than any other case you could ever imagine. Absolutely true. But the state didn't do that. Instead, they went on cruises. It's like, hey, man, you know that the whole country is going to be watching you with a microscope. You would make sure you didn't park over the line. You know what I'm saying? It's like, it's pretty close. Like, am I touching that line? Yeah, I guess I am. I better move it because all of the scrutiny on you. Now here, they're going to Aruba. All right. So over the past several years, Fani has done the opposite. She's using the media to turn the screws on each one of the defendants, long before we had any jurors even called here. Now, these media appearances by a publicly elected prosecutor called Fani are incredibly improper. But more importantly, they were designed to tear down our client's rights. Now, this case should be and could have been tried on the evidence admitted at trial. But because of the actions of Fani, can't do that anymore, Judge. The damage is done. That's why there are specific rules to stop them from doing this. They're not supposed to get out and increase the public's condemnation before we even have any trial. That is why Fani and Wade must be disqualified. Now, it is evident, Your Honor, that Fani and her personally appointed Wade have enriched themselves off this case. Now, that enrichment has taken various forms, not the least of which is the incredible amounts of money that Nathan got from Fani that has in turn resulted in Fani going on vacations, hotels, and the like that have nothing to do with this case or her official duties as a prosecutor. Now, this enrichment of Fani is a form of self-dealing. It creates a personal interest for her in this case. In other words, the more work that is done on the case, regardless of what justice calls for, what we were screaming about here, the more they get paid. If Nathan Wade turns around and says, listen, baby, Fani, honey, you know I love you. Okay, but we got to dump this case, okay? There's nothing remotely close to evidence in here that's going to lead to a conviction. I already had to give, this is Nathan Wade speaking, I already had to give Sidney Powell a deal, Jenna Ellis a plea deal, I had to give Kenneth Chesebro and Scott Hall all plea deals, and they're all diversion deals. I couldn't even get a conviction out of those dudes and gals. And so now, honey, Fani, you want me to go against Trump? I can't do it. Baby, I got to dismiss this case. She's like, but we got a cruise next month we're going on. We just bought that new trip to Norway. He's like, I know, but I got other money from my law firm. We'll figure. No, but he's like, hey, I want to fly first class this time. He's like, all right, fine. I guess we'll have another pretrial conference. They schedule it for another court date, right? That's the point. It's prosecution for pay. If he dismisses the case, it's gone. The more they fight Mr. Roman's motions, the more they get paid. The more they refuse to dismiss the defendants who should not be indicted, the more money they make. It's billable hours, baby. And of course, the more money that Wade makes, the more money Fani gets to reap the benefits from. Yeah, first class, man. Don't they know who she is? Now, these benefits are concrete, personal, and they're financial. They're also at odds with her obligation to seek justice. And that's why there is a conflict of interest, regardless of when their relationship began. But it is not just these financial words, Your Honor, that infect this case now. This case is different and everyone knows it. It's not the average case. It's not even an average RICO case. It targets public and private officials and the former president. It has and will continue to garner significant attention. And in this context, it belies belief that Fani would sit for so many media appearances and make so many publicly available statements about this case. All of her statements were calculated to enhance her professional image. She had a book written about her. She even hired a company with public money to track the public perception of her statements. Do they like what I'm saying out there? Perhaps even more alarming is Fani. She gave interviews to two authors writing a book about this case that has now been published and now it's available for public consumption. Fani, for some reason, believed that giving the authors of book access to her staff and allowing them to publish this before the trial started should not be scrutinized or questioned. She granted this unprecedented media access so she could taint the jury pool, thus making a conviction much more likely, and use the conviction to open doors for a new political future. Maybe she'll run for governor. And she wanted her rise to fame documented for the world to see, tainting up all of Fulton County. Now, they say, Mr. Roman, by the way, says that Nathan Wade's affidavit, which you might call a lie, he said the relationship did not start until 2022. We know that's not true. They call it patently false because they were indicting each other in their judicial robes with their gavels at a conference. So here's what they say. All right, Judge, with all that unfolding before us, we are speeding toward a precipice in this case. In Mr. Roman's view, if we proceed as Fani wants, we're going to all go over the constitutional cliff together. This court has the power to put the brakes on, to inquire further into what's happening here, to hold an evidentiary hearing, and to allow Mr. Roman to question these witnesses so that we don't fall off that cliff. Now, our client, Mr. Roman, a defendant, is asking for nothing more than what the Constitution demands. The state, on the other hand, Fani, would ask this court to go blindly in the dark. They are objecting to everything that we're trying to do to shine a big, beautiful spotlight on this issue. The state's strategy here is obvious and purposeful. They say Fani is trying to do a couple things. One, avoid having to answer any real questions. They use inflammatory, they use dogmatic, defensive rhetoric to falsely minimize what's happening here. They also try to avoid answering any actual questions because they don't want Willis to have to testify under oath. They just submitted an affidavit. Oops, that's good enough. Now, they also want Fani to avoid having to answer any real questions by also not addressing any of the financial disclosure problems. And they want to say that the relationship started after he started making money on the case. Not true. They also don't want her to answer any real questions at all. They don't want an evidentiary hearing in the first place. And they want all their subpoenas quashed so that none of their witnesses have to come and testify. How come, Fani, if all of this was above board, if you were doing your job like an actual prosecutor who was following the rules and being honest, none of this would be a problem. You could just show up and explain yourself. But in light of the obvious and the continued strategic obfuscation by Fani and the stonewalling, the adage that the lady doth protest too much, methinks. The lady doth protest too much, methinks. It rings true. This court has the power and the duty to inquire further into the potential conflict of interest. And our client, Mr. Roman, he submits that the testimony in this case, as proffered below, if allowed, we're going to be able to show that both Fani and Nathan Wade have violated their legal and ethical obligations, and they should be disqualified. Footnote 4 says, undersigned counsel, the Ashley Merchant, who signed this, has a good faith basis to believe that following the filing of Roman's motions on January 8th, Willis and her office asked its employees to sign non-disclosure agreements. Wow! That was confirmed through a news story on WSB Channel 2. So as soon as Roman submits his filing, he says Fani is indicting Wade, and Wade's indicting Fani, you know? A lot of indicting going on in Fulton County, and no one's a real defendant in those. But as soon as the story broke, as soon as the motion came in, she says, all right, everybody, time for a team meeting. She calls me like, oh, gosh, Fani called us in. It's Friday. You know, hi, everybody. This is Fani. I just want you to know I care about you. I just need you to sign this small form. It just says you can't talk about anything you've seen here between me and Nathan Wade for the last 4 years. Cool? Sign it. So that's what happens, right? Now here, they give us some more background. They say here, Roman asks nothing more than an opportunity to present this evidence. That's all. We just want to have a hearing on it so we can shine some light, shine some sunlight, baby, beautiful sunlight down on that conduct. And for these reasons, we ask that you specifically grant an evidentiary hearing, and then after the hearing, grant the motion to dismiss the RICO case and disqualify Willis and Wade. So here are some additional facts. And we like when we get a new additional factual background section on a Wade filing. Doesn't happen all that often, but it's good. Let's see. They say, all right, Judge, just to be clear a couple of these things up. On February 2nd, the court finally learned that Mr. Roman was correct, proven true, when he asserted that Wade and Willis have been indicting each other. Now, this fact was confirmed in the state's response, they implied, yeah, it's true, but they didn't expressly admit it. Now, this fact was never disclosed. Okay, so boom, we've been proven true. These two are in a relationship, but it has never been disclosed until the state filed its response. The first time we learned about it is when they admitted it, like they didn't voluntarily tell anybody about it until they were forced to. Wade admitted to the relationship expressly, publicly, and under oath. But Willis, Fani, still has not. Which is a little inappropriate. You know, don't you do that thing together like if you're a couple? Like you hold hands, you're like, you ready? Let's go. You open the doors together. This is our future. Let's go talk to them together. Willis and Wade's like, baby, like you're not even acknowledging me. I acknowledged you. I wrote my affidavit. You said you said you love me. Huh. So, you know, it's going to be a tough Valentine's Day for them. So they continue. They say Willis and Wade, they claim that they did not have a personal romantic relationship before Willis appointed Wade as the special prosecutor. We were innocent. There was no love going on. I appointed him, meaning the appointment was just totally above board. You know, no conflicts there. Then they started their indictments. But Terrence Bradley, aka Bradley, as we'll call him moving forward, he is going to refute that claim. Oh, who is our friend Bradley? Well, Bradley is an attorney and he's a member of the Georgia State Bar. Now, Bradley and Wade, they were friends and they were business associates. And Bradley, he has non-privileged personal knowledge that the romantic relationship between Wade and Willis, it began prior to Willis being sworn as the DA. Wow. So a long time ago, way back before January 2021. Thus, Bradley can confirm that Willis contracted with Wade after Wade and Willis began their indictments, thus rebutting Wade's claim in his affidavit that they did not start dating until 2022, which is a lie, right? I mean, if that's true, they began, unless he's like, you know, we're talking about the definition of what is again. It's like, oh gosh, we're doing this again. Well, what do you mean a romantic relationship? He's like, we were just, you know, indicting each other. That doesn't mean anything. I indict people all the time. You know, that doesn't mean I'm in a romantic relationship with them. You know what I'm saying? You know where this is going? He's like, Fani, she didn't mean anything to me until she like pinned me down and she's like, I want to be something with you. I see a future together with you, Nathan. He's like, all right, fine. So now we're boyfriend, girlfriend. Okay, fine. So the romantic relationship, right? She talks him into it. And then he says, well, that's what happened in 2022. And they're like, no, bro. That's not how this works. You were indicting her a long time ago. And this indictment happened before she was even the DA. So Bradley obtained information. Bradley got this about the relationship between Wade and Willis directly from Wade. Wow. When Wade was not seeking legal advice from Bradley. He's like, dude, check this out. Me and the county attorney. Yeah, I know, in our robes. Bradley obtained this information in a personal capacity as Wade's friend prior to Wade's decision to file for the divorce. It's that bro talk, man. While Bradley would later represent Wade for a time in his divorce proceeding, the information in the relationship was obtained prior to any attorney-client relationship beginning. So there's Bradley Wade friend bro talk, and there's Bradley Wade attorney talk. So they say, we're only talking about the bro talk. None of Bradley's testimony will relate to any privileged attorney-client communication. So it's just two bros talking and we're just broing it out. So Bradley also has personal knowledge that Wade and Willis, they regularly stayed together at Fani's home until Willis's father moved into her home sometime in 2020. Yeah, Dad showed up and kicked Nathan out. He's like, are you married? Are you in here fornicating with my daughter? No, not in this household, says Dad. Get the hell out of here. And so they throw Nathan out. Now, so that's an interesting witness, and we'll hear from him. Now, this guy, right, is going to probably have to testify first to lay some of the foundation to get in some of these other witnesses, as we'll see in the hearing. But big witness, Bradley's going to be a big one. This one, Robin Yurty, a.k.a. Yurty, moving out now, was also an employee of Fulton County and also a longtime friend of Willis. Yurty and Willis, they lived together for a time in a residence in Fulton County. When Yurty moved out, Willis continued to live there. Why do they all live together? Like, why don't they have their own places? Willis continued living at the residence. Bradley will confirm that Willis and Wade, they then stayed together at this apartment until her employment was terminated, at which time Willis and Wade began staying in what was commonly known as a, quote, safe house. That's why, because they don't want other people to see them. Rented for Willis. So there was a safe house rented for Willis, and Willis and Wade stayed together at both residences regularly, bouncing around, hiding stuff, right? So Fani staying with Yurty, and who knows how often Yurty's there. Weird. Like, why are they, don't you just have a house that you just live at? Like, why are you bouncing around from all these people? Anyways, so that's what's happening. So we got these two witnesses, Robin Yurty and Bradley, and there are two things that this go to. So first of all, Bradley can say that Nathan Wade's a liar because he said the relationship, the romantic relationship, however you define that, he says it didn't start until 2022. They might have been indicting each other, but it's just simple indictments. Didn't mean anything to anybody. Okay. Then their boyfriend, girlfriend, 2022, however they want to, finagle that. He says, look, I don't care what the testimony is. They were indicting each other a long time ago. So take it for what it's worth, Judge. Number two, Robin Yurty. Remember, they said that they did not cohabitate together. Nathan said we never cohabitated together. This is all above board, whatever. Not true. So Yurty comes in and blows that one out of the water too. We also have some additional invoices. They say since the filing of Mr. Roman's initial motion, his lawyer has obtained additional invoices for Wade. And this has been a big battle, kind of a cat and mouse game. The defense wants access to more information, more data, more materials, more discovery. The Fulton County office is just saying, we don't really have access to that. We don't have that. It's not in our possession. And so it's been this, back and forth, this dragging on to get evidence. So here they got some more stuff. They say the Fulton County office has still failed to produce others, but here is what we do get. So April, 35 grand, May, 40 grand, June, 33 grand. State did not give July, repeated open records request. They don't have that invoice. It's like, oh my gosh, what kind of office is this? August, 35 grand, September, 34 grand, invoice 25. Don't have that one. Oops. 37 grand in October, and November is only 16 grand. So that's some good money, man, for like a single case, essentially. Now, it's 19 co-defendants, but he gave 4 of them diversion deals. So, I don't know what he was doing because they all got diversion deals, which you can write up. I mean, it's crazy. You can write up a diversion deal. Oftentimes, they write up diversion deals at your very first court date. I can't explain this enough, but the original plea deals, all of this work resulted in 4 guilty pleas that will turn into dismissals of the case. So a guilty plea just means they accepted a plea. But the sentence, the penalty, is going to be a dismissal of those cases. So there will be not any conviction, and there will not even be a guilty plea. There will be no record of their charges. It's called a diversion. Happens all the time. You get it in first offense shoplifting cases. Oh, you stole something? Okay, here. Don't do it again. Take this class, diversion, you're done. Right? It's crazy. And they agree it's such a low effort, low bandwidth criminal mechanism. You don't even need to do any research, right, to actually get to, and if you're just going to give that away. So I don't know what he was billing for, honestly. I'd like to see his logs. I'd love to see his notes because my guess is there's almost nothing. They don't even have the invoices. Mr. Roman also has been able to obtain details about various trips, and they were on vacation. It's hard to do work when you're on vacation. Wade and Willis, they flew to Miami. They boarded the Royal Caribbean back in October. Wade paid for Willis's flight. They left Atlanta to Miami. They shared a cruise cabin. Wow. Not very professional there. Looking over the ocean on a cruise with your special prosecutor. Incredible. Wade paid a total of $1,200 to American Airlines for both flights. He then paid $1,300 for their shared cabin on the trip, which is cohabitation. So Wade lied to the court. They're laying there together, unless he slept outside. He also paid an additional $1,000 to Royal Caribbean during this cruise. I wonder what that was for. In-room entertainment. In total, Wade paid $3,500 for this vacation. That didn't include any transportation. We also had a trip to Aruba in November. It's like, hey man, hey babe, you just got back. You just come back from the Bahamas, That's a lot of work. Taking a trip to the Bahamas, it's a lot of work. And so, I've never been fortunate enough to go to the Bahamas because I'm not prosecuting a former president and stealing $1 million off the taxpayers, but I'm sure it's a lot of work. And so as soon as you come back in October, you're going to need another vacation to deal with that. So in November, right after October, the next month, you have to go to Aruba. So let's go to Aruba. Nobody caught us when we went to the Bahamas. So then Wade, literally the next month, November 1st to November 4th, he paid to go to a trip in Aruba. Flights and hotels, Vacation Express for $3,800. Wade also paid an additional $370 to the Hyatt. They also shared a room there, cohabitation again. Now, this does not include transportation. And then, as soon as you're done in November, October, November, that other crew, you're probably pretty tired, from those two cruises. So you know what a great way to recover from your first two cruises? A third cruise in December, the next month. This is crazy. December 2022 to January 2023, they take another cruise. This time, they're on a Norwegian. Paid $31.70 for flights and the cruise itself. He got an island Jeep rental for $98. He paid $198 to Rum Runners Freeport, and then paid more money to the Norwegian Cruise Line for $214. In all, he paid $3,600 for this vacation. And it's like month after month. This is what I'm saying. There's no work done on this case. How could you? It's like you got to plan for a trip. And so here, Wade took Willis to Belize. Okay, so December goes by. They come back in January. They're like, we should probably get some work done. So then they work a little bit January, a little bit February. They're like, we're exhausted. What do you want to do, sweetheart? Well, you just made 34 grand last month. Let's go on another vacation. Love you. So Wade, he then takes Willis to Belize. Wow, that's fancy. He paid for them to stay at the Phoenix Resort. That was $1,700. Then they went to the Ambergee Grand. That's another $1,000. And look at this. They spent $74 at a tattoo parlor. What did they get? What did Fani get on her big fanny, huh? Is it Nathan Wade? Is it NW with a heart right here on her fanny? What did she get on there? What was that? Was it Nathan's face at the tattoo parlor? Amazing. So somebody should audit that. I'd like to know first, what was it and where was it? What were you doing with the tattoo? Could have been a Nathan's hot dog all across the small of her lower back. Nathan's hot dog. Her favorite. Also, $363 at local restaurants. Yeah, for the hot dogs. You never know. So then they come back in March. They're like, all right, we're going to do a little bit of work on April. In April. How many of you, my friends, have not been on vacation in a year or longer than that? They're already in like five vacations already. Okay. Roughly 2 months later, Wade then took Willis to Napa Valley in May, right? So they take a little bit of time off in April. They come back in May. He then purchased their flights to San Francisco. That was $840 for their hotel in Napa Valley. And just the trips on this flight is $1,658 as well. So the foregoing trips surely are not the only payments that Wade has made that have personally financially benefited Willis. They say if, as Bradley, the witness, confirms, Willis and Wade, if they were in a romantic relationship before she took office, Wade likely provided Willis with other significant gifts and benefits. Of course, the state and Wade have now filed motions to quash these subpoenas because they don't want us to discover these things. And we'll see if, Fani ultimately testifies. If she had any honor at all, she would have resigned a long time ago. And she might still resign before this hearing takes place on Thursday. I would not be surprised if she did, because it's going to be bloody. Now, Wade also paid for a number of Uber rides associated, but those are not added to the totals. We'll just write off your Ubers. So here we continue. More facts. Now, Willis also gave statements to authors of this book. And of course, what that did is poison the jury pool. She's not supposed to do that. She's a prosecutor. Even Merrick Garland comes out here and he can mutter out these words. We speak through our filings in the court of law. Thanks, Merrick. On January 30th, this group called the Hatchet Book Group, they published this book called Find Me the Votes, a hard-charging Georgia prosecutor. I believe that. And a rogue president, and the plot to steal an election. Should be the plot to steal $1 million from Fulton County, which is actually true. Now, the DA talked about the ongoing case, and she made a number of statements in the book, and apparently those efforts were made to boost her public interest, her image. Another way that she personally benefited from the case. Here are some excerpts from the book. Now, before Willis made the decision to run for DA against Paul Howard, she worried that if she lost, she would end up in financial straits again. She told the authors of the book that she was thinking, she says, quote, I really don't want to be financially effed up again. That's good. So you're running for office so you can make money? Like that's what it is? Okay. Now, the book was not published until January 30th, 2024, so just about 2 weeks ago. And Mr. Roman did not have an opportunity to read the book prior to filing the motion before the deadlines. So Ashley Merchant has just been going hog wild. So I got to have time to read your stupid book. But now I have. And now we're supplementing the record. Now, they say the book, while Miss Willis was on the fence about running for DA, she consulted with Kendall, who is her convicted former boss, and told her a story is going to come out that Paul Howard can't survive. After deciding to run against Paul Howard, Willis claimed that Howard engaged in an egregious abuse of power and that he was just a bully. Now, after becoming the DA and following an interview given by Brad Raffensperger, you remember him, the Georgia Secretary of State, Willis issued a press statement telling the public how she approached the investigation. She wrote letters. The authors explained that Willis was flooded with media requests, and she showed up on the Rachel Maddow show. And we've played that clip here before. In another interview, during Willis's investigation into Fulton County, she also told a reporter, if somebody did something as serious as interfere with somebody's right to vote, we're going to invest in that. Now, it's not clear if Willis disclosed her personal relationship with Wade to the authors. We don't know. But her personal relationship with Wade is not mentioned in the book. Incredibly, the book contains detailed information about a normally secret grand jury proceeding, leading the obvious to question about how the authors got information about this. Apparently, there's a personal biography of the foreperson of the grand jury, and the authors were given full access because they were able to comment on her thought process. The book describes very specific things about special grand juries, which are all supposed to be sealed. It also discussed the disputes amongst grand jurors and other things. Now, the obvious intent of this whole book is to bolster her credibility, check all the boxes, and make her look amazing. It appears as though the authors were given specific information and info about telephone calls where Wade and Willis were the parties. The authors also detail communications, talking about getting obscene and racist messages. Willis also revealed the discussion with a woman who told her God had instructed her to pray with Willis before her big announcement, saying, I sought protection from God. Now, the author's access to Willis and her thoughts did not end at the indictment. Willis has given them a ton of information, saying her team was rushing to prepare. They were holding mock trials. The book readies for conclusion by describing Willis as someone with considerable skills as a prosecutor. I have not seen that at all. And this was before any of the Wade stuff. I mean, we talked about this at the outset, how weak I thought her office was. And we also saw Fani actually do some lawyering, to her credit, which is good. Letitia never did any. Jack Smith doesn't do any. So at least she stood up there and tried to incarcerate Harrison Floyd, and she failed at that. It was embarrassing. It's like, oh my gosh, like obviously that was not going to go your way, Fani. So, right, they're trying to puff her up. Now, the authors they're saying she's bolstering her own ability. She was going to be like this hero. They were going to parade her around the election and so on. Not anymore. So then she went and she gave a racially charged speech at the church. We're familiar with this. She says, "Why, God, why? I hired one white woman who she didn't sleep with. I hired one white man who she didn't sleep with, racist. Then I hired one black man who she did sleep with." She called everybody a bunch of racists for that decision. All of that is what she said. And there were all sorts of headlines, right? Everybody took her speech where she called all of the defendants racists, and they promulgated that all over the media. Now, the media interpreted Willis's statements as accusing her critics of racism. And there's a bunch of quotes about that. And that's a problem. She's also made numerous extrajudicial statements to the media that's going to inflate her perception in public and prejudice everyone else. Lots of media, various outlets. She's been all over the place 38 times. Her media appearances were part of a concerted and a calculated effort to boost her campaign. And so there's a bunch of examples of this. You can see they are detailing them on that YouTube video linked here. But now we get to some argument. They say, look, Mr. Roman requests we have an evidentiary hearing. We want to talk about this. They say with regard to other inquiries, there's a bunch of stuff that we can dig into. There are a bunch of issues that need to be decided. Wade has conceded in his affidavit, right? Because he just said, I don't need to testify. Here's the truth. Here's what happened. And she says, Ashley Merchant says, sorry, it's not even admissible. It's ex parte. We don't really care what's in it. Now, the issue with regard to the disqualifying interest is the same. Did Willis or Wade receive a personal interest in Mr. Roman's prosecution? That's the question we're trying to answer. And we're going to present evidence related to her misconduct. Willis has made numerous extrajudicial statements, made numerous interviews, and provided with all sorts of other statements designed to infect and taint the jury pool and interfere with the right to a fair trial. Now, Mr. Roman anticipates presenting evidence from witnesses for whom these subpoenas have been issued. Mr. Roman also anticipates introducing various business records and other materials, including invoices. Georgia law tells about proffers. We're going to hear the judge talk about this in the next segment because there was a full hearing on this today. Now, as shown below in more details, there is a lot of evidence that we can talk about. A lot of case law here, as you can see, talking about the Court of Appeals, United States versus Winkle, saying the court must be able to rely upon counsel's representation that there's a possibility of a conflict. In this case, Mr. Roman and other defendants have given this court plenty of information. Mr. Roman's original motion articulates there is at least a potential conflict, and we've proffered evidence that there was a personal relationship prior to any of this happening. We also, Judge, communicated that Willis and Wade took trips together. There was a financial benefit from the appointment of Wade. Wade and Willis, they intentionally failed to disclose their relationship. They didn't do it until they were forced to. And it's all indicia of their actual conflict. We also highlighted a significant amount of money that Wade has made. He's got irregularities in his invoices. A lot of money that's provided to Wade are significantly more than the other prosecutors got. And so this is why there is a particular conflict here. And so based on the foregoing, they say, Judge, if you fail to conduct an evidentiary hearing, the court will necessarily violate Mr. Roman's due process rights. And so accordingly, we respectfully request that the court conduct an evidentiary hearing and disqualify Fani and Wade. So this is the rest of the motion. Of course, there's a lot more going on here. A lot of it is pretty technical stuff. So let's fast forward to the conclusion and see what they have for us before we poke around Atlanta and see what else is going on. because this was a whopper. We got through most of the facts there, and let's see how they conclude this thing on the final page as they articulate what they're asking for. Getting closer. They say the state here spends considerable time saying that Fani did need to go through the approval process. And so as they wrap up this filing, they're talking about some of the technicalities, right? What did Fani do in order to even get Wade appointed? She failed to get proper approval. And so everything that comes as a result of his illegal appointment needs to go. So here they say, in conclusion, in light of Willis's actions in this case, Fani has failed to remain above suspicion, and in the interest of preserving Roman's rights, the court should order the disqualification of Willis, her office, and all of the specially appointed prosecutors. Signed and submitted by the very great and extraordinary defense attorney Ashley Merchant out of Georgia, doing awesome work on this and blowing the lid off the whole thing. And so that is what has been submitted. Now, there was a hearing on this motion that we're going to cover in the next segment, so click over there if you want to catch that one. But there's other updates in Georgia, including this concept about accepting service on a subpoena. Fani Willis apparently doesn't know how to do that. Remember that she's also been subpoenaed, not only in Fulton County, but by Congress. Jim Jordan and others are saying, we want to know if any of that money that you funneled over to Nathan Wade is Fed government money, those federal funds that we can claw back. Well, Jordan sent her a subpoena. We've read that here on this channel previously. And now she has ignored it. So apparently they sent over the U.S. Marshals to hand deliver it to her personally. Okay, Jim Jordan sent a subpoena back previously, but Willis did not accept the subpoena after it was emailed. So the U.S. Marshals had to go serve it to her themselves. Someone asked, why wouldn't Fani just accept service like anyone else? I don't know. It's really dumb. Like, are you fleeing the country, Fani? Like, they're going to find you. Are you going to go to your safe house? You're a government official. Hello. Making the U.S. Marshal Service use taxpayer money to do this is a complete waste of time. Fulton County's office did not immediately respond to this, and the House Judiciary Committee is the entity that demanded access to some of that additional information. And so they sent her a subpoena that apparently she is ignoring. So not a good move, but it's Fani we're talking about. Our friend Julie Kelly on the X platform at Julie_Kelly2, who's a great follow and does great work at declassified.live. I'd encourage you to check that out. She posted this. She says, oops, these lawyers just admitted that Fani Willis is also getting help from outside attorneys to write her filings. Like, why is that? You have a whole attorney's office there called the Fulton County Attorney's Office. So here is what they said.
So, yeah, the writing's been splendid, notably so. This 176-page motion actually got an assist. We don't know, I don't know exactly who it was, but there have been some outside lawyers who've been joining the cause. You know, we have just everything is so different, and they're in a fishbowl, but that includes then people who want to be helpful if they can. In terms of the overall lawyering of the case, I see, you know, I think it's been solid, though I have from the start thought, wow, charging it as a RICO has a lot of implications, and I care the most about speed. And I think that it's a big vehicle to try to lumber down the road and also be quick. So
yeah, RICO is kind of dumb because what happens now is you've got now 19 lawyers who are all digging into this stuff, and one of them's going to crack something, one of them's going to find something. Ashley Merchant did that, but pretty amazing that there are outside lawyers coming in. That means that other lawyers are like us here watching this train wreck. Now, we're not offering our assistance to Fani, but we've seen this train wreck coming from a mile away. And so a bunch of other, you know, probably lefty lawyers are all piling in here. You might want to try this. You might want to do this. You might want to do that, because they're so interested in getting a conviction before the election. So this is also now what's happening in Georgia. Apparently senators are digging into this, talking about reviewing Fani Willis. So she's not only dealing with it in the courts, but also dealing with it in the congressional branch and the bodies there in Georgia. Here's the report from 11 Alive in Georgia.
First tonight at 6 today, a state Senate committee started its investigation into the Fulton County District Attorney's Office. This committee is now looking into what some members are calling prosecution for profit.
They're examining a personal relationship between the Fulton County District Attorney and a special prosecutor hired to take on the election interference case against former President Donald Trump and others. 11 Alive's Doug Richards is live at the Capitol with more tonight. Doug?
Yeah, you know, the creation of this committee last week had a rather strong partisan whiff to it, with Republicans supporting the creation and the Democrats opposing it. Today, when the committee actually met for the first time, lawmakers sort of masked it with rhetorical, maybe perfume, which kept that whiff down to a dull roar. The Republicans outnumbered Democrats 2-1 on the 9-member special committee on investigations. On this first day, Republicans stressed how much they included Democrats on the rules and procedures as the panel investigates Fulton DA Fani Willis.
We have both parties included in this committee for a reason. We are serious about the business we're conducting. We're not doing this for publicity. This is a quest for the truth.
Republican Bill Cowsert of Athens will lead the panel, which will have subpoena power, will take sworn testimony, and will encourage confidential informants to come forward.
Wow.
It will raise
That's almost like a little, J6 committee.
questions about DA Willis and her personal relationship with Special Prosecutor Nathan Wade. Together, they are pursuing criminal election interference charges against former President Donald Trump and a list of co-defendants. Democrat Gloria Butler says she's willing to give the Trump allies on the panel the benefit of the doubt for now.
It is my hope that this committee conduct itself in a responsible fashion and pursue the truth.
Yeah, that's what they're going to do, Gloria. You're right. Hopefully they do that. We agree.
Given that you will seek testimony from Fani Willis?
It's not a given.
No.
You know, if I will certainly give her the opportunity, and if I were her, I would want to be heard.
If Willis were to testify, Cowsert says that Republicans would have, in his words, no prejudgments about whatever it is that she would bring to the table testimony-wise. Cowsert told us today that he expects the work of this committee to go on for months, past the adjournment of the legislative session underway now that's due to expire in late March. We're live at the Capitol tonight.
All right, so
attention to the vital.
They are going to have a full-blown hearing on that thing, and that's going to be very interesting to watch as the evidence continues to come out, exposing Fani Willis. The biggest Fani in Georgia is in some serious hot water, right? Every day we come back here, there's even more evidence. Now we've got a 66-page supplemental, and we have a hearing coming up, which we're going to hear in the next segment. So stick around or click over to the next segment because we got the full hearing. Judge Scott McAfee listened to all this, read it, and then came to his conclusion. The hearing is on. And so make sure you're subscribed, my friends, wherever it is you're watching this. Thanks for liking this video and joining us, because the Fani Wade saga is only just now heating up, and we're going to continue to cover it along with all of the other Trump indictments. Thank you for joining us as we do. And while you're here, don't forget to check out some of the links down in the description below, including watcherlodge.com. We have a great event coming up this Friday called Political Zen Wellness, and we're going to be doing a lot of fun stuff with our friend Jason Campbell. So go follow the link, sign up, make sure you come back here. We'll see you back on the next one. But we're not done yet, my friends. So stick around because we're jumping right into it. The actual hearing is next. Fani Willis fails to quash those subpoenas. She did not want to testify in Scott McAfee's courtroom, the judge in the RICO case, but she's got to be on call because the subpoena is still in effect. We're going to go into the hearing and see exactly what happened, but this is the order that Scott McAfee, the judge, released, notifying all of the people that there is a hearing on the motions to quash. Fani does not want to testify, so her team submitted a motion to quash Robin Yurti. Don't want her to come and testify. She was a former employee of Fani's office. We also have a motion to quash Nathan Wade. Do not want him, the special counsel, to come and testify. And lastly, of course, the motion to quash the FCDA, the Fulton County District Attorney. Fani does not want to testify. but she might have to. Judge McAfee said that the hearing is on, and we're going to jump right into the court proceedings that happened today. Now, what we're going to do as we play through this is hit the highlights on this. We're going to pick up the speed a little bit. We're going to be at 1.25 so we can go quickly because they talk slowly. But we're also going to hear some initial arguments from Ashley Merchant, and then, of course, from this woman, Anna Cross. Anna Cross, you see here on your screen, is one of the attorneys from Fulton County who has been hired to deal with a lot of this litigation. So we're going to hear from her and others, including Ashley Merchant, who you can see kind of tucked back here right in this screen, this box right here. Ashley Merchant is in the pink. You can also see her in this screen as well. We're going to start. I fast forward through some of the intro stuff. Scott McAfee is going to pick us up, and he is going to explain what we're doing here. Backdrop is an evidentiary hearing is coming up in just a few days. Fani is racing to not testify. So they're trying to stop her and Nathan and Yurdi from having to testify. Judge McAfee says, sorry, hearing's on. And here's what it sounds like.
Really right for review. The next issue, I think a little more to cover here. Again, just to set the stage of where we're at, and I'll allow counsel to weigh in when we get to it, but just want to make my initial observations and findings of where we're going today and the rest of this week. So several of the motions to quash today are arguing that we shouldn't have a evidentiary hearing at all, and that quash is appropriate on those grounds. So to that end, in studying the law that's been filed up to this point, I think it's clear that disqualification can occur if evidence is produced demonstrating an actual conflict or the appearance of one. And the filings submitted on this issue so far have presented a conflict in the evidence that can't be resolved as a matter of law.
Okay, so that is the judge saying there is a problem here. The law says I might be able to disqualify her, so I have to hear this in order to make a decision. I cannot just allow this to go forward without sitting here. So let's slow this down a little bit, and then I'll pick up the speed again.
Specifically looking at Defendant Roman's motion, it alleges a personal relationship that resulted in a financial benefit to the district attorney, and that is no longer a matter of complete speculation.
Yep.
The state has admitted a relationship existed, and so what remains to be proven is the existence and extent of any financial benefit. Again, if there even was one. So, because I think it's possible that the facts alleged by the defendant could result in disqualification, I think an evidentiary hearing must occur to establish the record on those core allegations.
Yes, good call, Judge.
So just to emphasize, I think the issues at point here are whether a relationship existed, whether that relationship was romantic or non-romantic in nature, when it formed, and whether it continues. And that's only relevant because it's in combination with the question of the existence and extent of any personal benefit conveyed as a result of their relationship. With that being said, I don't think that means that everything that has been raised in the defendant's motions, and Mr. Roman's or in the ones adopted by co-counsel, demand an evidentiary hearing. The testimony that would be produced at this hearing is not a deposition. It is still subject to the rules of evidence. And so I think the facts that are going to be developed on the record have to have some relevance and some materiality. Now, contradictions or how things play out could impact that, could change what is relevant. But at the outset, there are a few things that I don't think are. So to that end, I don't think the particulars of Mr. Wade's experience are relevant.
Okay, so pausing, the judge says, we're having a hearing. We need to have a hearing. There's a bunch of stuff that is a problem, and we're asking about the extent of the damage, essentially. But there's a bunch of other stuff that I'm not going to care about. So we're having the hearing, but we're only talking about some things. Some things we're not talking about are Nathan Wade's experience.
I don't think those are material for an evidentiary hearing. His alleged lack of experience handling RICO cases or any inferences regarding the intent from that can be addressed at argument. But in my mind, as long as a lawyer has a heartbeat and a bar card, that lawyer's appointment standing alone is a matter within the district attorney's discretion.
So don't need to talk
similarly,
about all that.
I haven't found a reason to find that the regulations or the alleged violations of Fulton County Code are relevant in and of themselves.
That's fine too.
I think the violations of these rules can be argued as a matter of law if counsel wish to do that. But I've yet to see case law
those are small,
anything
kind of
indicating that
minor
these
issues.
violations, if they did occur, are relevant to disqualification or a pending criminal case. And then finally, the motions have also evolved to include forensic misconduct on behalf of the district attorney. And again, I don't see how these are a necessary topic for an evidentiary hearing unless it's made an issue in some way. The public statements in my mind speak for themselves, and the application of the law to those statements can be argued. And I don't think any further testimony qualifying them is going to affect the analysis. So with that being said,
So we're going to have a hearing. I'm going to keep it narrowly circumscribed. Some things we'll talk about, some things we won't. Just letting you know, giving you a heads up.
I'll turn it over, Ms. Merchant, to you just at the outset. If you have anything you want to preserve for the record or to reply on, and then from there we can take up the motions one by one.
No, Judge, we appreciate that narrowing issues, and we did plan on being narrow in the evidentiary issues that we were going to be litigating on Friday. As far as those topics, like you said, I think all of those things are already in the record, so we're just planning on arguing those as far as the law. But the evidence we'll get into a little bit deeper with the motions to quash.
All right.
Thank you, Judge.
Okay, so let's turn. I didn't really have an idea of the particular order, unless anyone's jumping up and down and says they have another conflict they need to get to. Why don't we start in the order that I received them? So I think the first one we got would have been from Ms. Cross on behalf of the district attorney. And Ms. Cross, the floor is yours.
All right. That's Anna Cross, one of the attorneys that was hired by Fani Willis to work this case. Now she's arguing why Fani Willis's motion should be quashed, right? Starting with Fani, the big one.
Thank you, Judge McAfee. And I appreciate the narrowing of the issues. I think that the state's motions to quash all relate to the areas that you consider to be available and open, so would be potentially still be the subject of any evidentiary hearing held this week. I think from the state's perspective, and as the court is aware, Ms. Merchant has subpoenaed a total of 9 employees of the district attorney's office, including the district attorney herself. Those range from the opposing counsel on the prosecution team prosecuting Mr. Defendant Roman, current and former members of that team. It includes individuals who have no direct relation with the prosecution, but also no relevant information, including the district attorney's personal executive assistant, members of her security detail, and other individuals who are employed by the office and quite outside the area that the court has determined to be of relevance in any future evidentiary hearing. The state's position is, and I think the evidence is clear, that these witnesses who Ms. Merchant or no opposing counsel has ever spoken to cannot be in good faith represented to the court as having information that would be relevant to any of the individual issues that the court has identified to being of interest. These witnesses, again, have never been spoken to, and nor Ms. Merchant nor anyone else can represent what they would say. I will represent, however, what they would say. They would not in any way support the wild speculation that was included in this motion. It would not support, as was raised in the reply brief that was filed this morning. Ms. Merchant represented that these witnesses subpoenaed, I think 2 weeks ago now, prior to the filing of Mr. Wade's affidavit, that any of these witnesses would refute the allegations or the representations that were made in the Wade affidavit. The allegations and the speculation from Mr. Roman's initial motion has been, I think, is clear to the court now. There have been several representations that were made that were not true, were not in good faith, could not be supported. These witnesses that have been subpoenaed now for a hearing this afternoon have nothing at all to add to the allegations that were made, nothing in support, nothing that would undermine the affirmations that were made in the Wade affidavit.
Yurdi used to work there.
The affirmations and the facts sworn by an officer of the court that were made are categorically true. They're 100% true. And there's no witness, certainly none of the 9 that were subpoenaed, that are representative of the district attorney's office that will say otherwise. We pointed out to the court all of the law that disfavors a defendant or any litigant subpoenaing opposing counsel or members of the opposing counsel's litigation team. A criminal defendant does not have the right to make claims without admissible evidence and then subpoena the other side in an effort to conjure up some evidence to support them.
It's not right. She's right. Like, it's not a good practice to subpoena each other's lawyers. Like, that's not like favored in law, you know, because it would be bedlam if everybody did that. But this is not a normal case. This is a serious case where there's major allegations of improprieties, conflicts of interest, and bias amongst your side.
That's not serious. That's an abuse of the subpoena power.
No, it's not.
It's the defendant's burden, now that the motion to quash has been filed, to establish the relevancy. And the state believes that there's just no way to make that claim in good faith, given the record that's before the court now. Let me phrase it this way. This is a serious case.
That's true.
These are serious charges.
That's true.
Your Honor has been running a serious courtroom.
Yep, that's true.
And in response to the accusations that were made, the state presented the court with law that establishes that even if all of the allegations were true, and they're not, that is not a basis to either dismiss the indictment or disqualify the district attorney's office. The state has brought you the law. The state has brought you facts in the form of a sworn affidavit from the officer of the court, identifying the timeline of the relationship, the facts as it relates to any financial involvement related to the allegations that were made. There is no personal interest on behalf of the district attorney or her office in the prosecution of this defendant.
And
there is no financial
cruises
interest
every
in
2
the
months.
prosecution or conviction of this defendant by the district attorney's office. The travel that was taken, as represented in the affidavit, was roughly equally divided between the two of them in terms of responsibility.
Not on those
And there's
months
no
that we
evidence
just
that
read.
can be brought that would dispute that. These are serious charges. The state has responded to them seriously. And I think the court's action here will be informed by the other motions to quash that you'll hear this afternoon. My understanding is that of all of the witnesses subpoenaed, there will be no individual who has relevant information that would dispute the affirmations in the Wade indictment. The defense is not bringing you facts. The defense is not bringing you law. The defense is bringing you gossip.
No.
And the state cannot, and the court should not, condone that practice. I understand the court's representation, or I understand the court's position that an evidentiary hearing is required. If that is required, none of the witnesses identified here in the state's motion are properly subject to subpoena. And so that's addressing the employees of the district attorney's office and the district attorney. The state also filed a motion to quash the subpoena to Mr. Bradley, I believe is his name. Mr. Bradley is someone who was a former business partner of, thank you, the former business partner of Mr. Wade. He was also his attorney related to divorce and domestic matters, and that relationship began in 2015. 2015 far predates any allegation relevant to the motions. That attorney-client representation continued through and including, I believe, 2022. There has been no waiver of privilege of that. And I believe that the evidence or the record before the court would demonstrate that defense counsel knows that this relationship, attorney-client relationship, exists, that she knows there will be a privilege invoked, and that it just is designed to obtain more public relations, more spectacle, and that the subpoena to Mr. Bradley should likewise be quashed.
Okay, so reading between the lines, what she's saying, I think, is that Bradley's going to come in, and we read in the prior segment the entire filing, the supplemental filing, where Bradley is this key witness. Bradley is a Wade law partner, ex-law partner, who's going to come in and apparently have information about these two indicting each other, Nathan and Fani, a long time ago, right before she even hired him. So there was some sort of Fani business happening between the two. But he is brought in, and she's saying that he's going to invoke, right? He's going to say, nope, attorney-client privilege, and then not say anything, right? Like not actually reveal the goods, not actually provide any of that data. What Ashley Merchant is going to very likely come out and argue in a minute is that it's separate, right? There's bro talk and there's attorney talk. And they were bros before they were attorneys, and they were doing bro talk about the relationship before they actually formalized a relationship. And then whatever happened in the actual divorce from Jocelyn shifted into attorney-client privilege stuff. And so the previous stuff doesn't count.
I believe Mr. Evans, if he's here now, will address in more detail the bank records, but given the court's representation, I won't go into that. I believe if that was included, please correct me if I'm wrong, but insofar as the subpoena has been issued for the bank records of Mr. Wade and his law practice personally and other entities associated with him, that's clearly a fishing expedition that the law does not permit. Yes, the court to quash that is overbroad and harassing.
All right. I think there's a lot to take up there. Ms. Merchant, I want to let you respond generally, and maybe we'll descend into the particulars afterward.
Great, thank you so much, Judge. Judge, a couple things on the state's response or the state's argument to quash, Judge. First, I'd just like to point out the state is asking that this sworn affidavit from an officer of the court, from Mr. Wade, be considered. But when we were in federal court, Ms. Cross argued that an affidavit is not admissible. We don't believe an affidavit is admissible in this case. You can cherry pick in an affidavit what you want to talk about, and there's no cross-examination. So that is not, it's not admissible. We put that in our brief. We've argued that. It's just not admissible. It's not relevant. It's
Wade's
hearsay.
Affidavit.
It's nothing more than hearsay.
And it's filled with lies.
We have a right to make a record on these allegations. And as long as we keep our evidence and our questions narrowly tailored to that inquiry, that is our right. We have a right to explore whether or not there was a personal or financial benefit to Ms. Willis from this relationship. And we have carefully chosen the witnesses that we have subpoenaed based on that. And I just want to walk through a couple of them. But before I do, before I move on the affidavit issue, Mr. Wade has filed other affidavits in his divorce case, which contradict this affidavit. His interrogatories, which were sworn and verified and filed in that case, said that he did not have a personal relationship, that there had been none. So we've got two declarations in two different courts, both sworn, both filed with the court, that say something completely different. His May, let's see, it was his May 2023 affidavit, where he was asked if he had, and this was in 2023, Judge. So the state's response last week said they had a relationship that began in 2022. In May of 2023, he filed in the Cobb County Superior Court a pleading that said specifically if he had had any relations with a person other than his spouse during the course of the marriage, and the typical things that are asked in a divorce case, and he responded none. After we filed our motion in this case, he updated those and he pled privilege under the Fifth Amendment. So
busted.
We've got a filing under oath by Mr. Wade in 2023 stating he didn't have a relationship.
Weird.
Then we've got a filing stating he did have one starting in 2022.
Weird.
And then once that came about, he fixes the incorrect affidavit that was filed back in 2023.
The dude can't even get his story straight. And then now he starts to plead the fifth. Which, if you're a judge, man, and a lawyer lied to you in your courtroom, they said an affidavit, I did not have, any relationships with that woman, like a Clinton type of deal, which is what Wade did. And now you have a competing interrogatory, which is, these are like interviews type questions that you get in other proceedings, civil proceedings. And so he has opposite answers in two different courts in the same state. That's weird. You're a lawyer. You're supposed to be honest and have candor with the court. These are in the rules. So amazing. She called him out on that. And that is a big, gosh, if you're the judge, you're like, what is this dude doing? He's just in big trouble. So he could, of course, still come back with it depends on what the definition of is defense. I can still see this from Nathan Wade and Fani. Again, they're just indictments. It's not a romantic relationship. So what if we did the hibbity-dibbity at the old judicial conference? Who cares? That has nothing to do with anything. We're not in a relationship. It's not a romantic relationship. It's just indictments. So maybe you can get away with that. Okay. But that's, that only works for Democrats and Bill Clinton. That doesn't work in most courts of law. It's like, come on, were you indicting her or not? You knew you were, and you made two different statements because you were trying to hide the fact and you were covering it up. That is, not only look, you can understand you get carried away. The heart is, you can't fight love, my friends, And so, okay, they make a mistake, they get in trouble, they resign, they call it a day or whatever, but they're digging their heels in on this, and they keep just adding layers to their excuse, and they keep getting busted in the result, in the aftermath.
So we definitely have a conflict, Judge, in the evidence as far as when this relationship started. Just from the hearsay affidavits.
From his own statements, from Nathan Wade himself.
There's also some other things in the Wade affidavit that we have conflicts in.
Yikes.
We've got the date. We've got whether or not they cohabitated, whether or not there were any funds that he was paid, that he used for travel with Miss Willis. We have quite a few documentations that we have attached to filings, and we have more that we intend to present at the hearing in this case to show that she did receive a lot of benefit, a lot of financial benefit.
Ashley's going to come in with a friggin' wheelbarrow of, manila file folders, and she's going to dump them on the courtroom floor. Here you go.
In the forms of different trips, plane tickets, hotel rooms, Ubers, dinners, things like that. We have all of those from the financial records, which I'll go into in just a minute to stay on task. I'll go into those in just a minute. But that's as far as Wade, why we think that Wade definitely should be called as a witness in this case. How can Mr. Wade not have relevant information to this inquiry?
He was doing
that
indicting.
is the real question here.
Yeah.
He probably has the most relevant information to this inquiry.
Nathan's
Same as Miss Willis. She probably has the most relevant information to this inquiry.
Yeah, she's the county attorney.
Mr. Bradley, the state has taken it upon themselves to file a motion to quash Mr. Bradley's subpoena. Mr. Bradley has not filed a motion to quash. The divorce in this case was not filed until November 2021. The only privilege that can be asserted is things that were said in furtherance of legal advice. So if Mr. Wade made statements or comments to Mr. Bradley in furtherance of legal advice, we're not going into any of that. We don't have any intention of getting into a privilege dispute, what was privileged and what was not. The relevant information that Mr. Bradley has to this inquiry is that this relationship started prior to Mr. Wade being appointed as a special prosecutor in this case. He has firsthand knowledge that this relationship predated that. He has knowledge, and not privileged knowledge, Judge. The divorce action hadn't even been filed at that point. He has personal knowledge, not privileged knowledge, that they had cohabitated, had stayed at the same place. And, you know, I certainly don't intend on getting into an argument over what the term cohabitated means. They had stayed together. Mr. Wade had stayed at places that Fulton County was paying for Miss Willis to stay at. He's got information about that. We have outlined all that. We've made a proffer. That is not privileged information, Judge.
And unlike some of the, I guess, other witnesses that are here challenging their subpoenas, my inference from the supplemental reply is that this is something that you have corresponded or communicated with Mr. Bradley about directly.
Yes, only non-privileged information. Yes, Judge.
And that's an interesting question. So, you know, is he going to come in? Because Anna said that Bradley's going to come in and basically invoke. It sounds like he's going to invoke. So it sounds like she's got a plan to get around that, or maybe he's told her that he won't invoke. In other words, Bradley will say, yeah, I'll answer questions about anything that was not privileged. You know, so we might have a difference of opinion about what this witness is going to do when he is called in.
And so let's put the district attorney and Mr. Wade in a separate category. I think you would still, now that the motion has been filed, need to make some kind of showing for the other 7 witnesses challenged by the state.
And Judge, sometimes when we subpoena witnesses, if they would be fallback witnesses, for example. If Miss Willis if you don't force Miss Willis to take the stand, then we would have to present witnesses to establish what Miss Willis could be questioned about. And so some of those witnesses would be cumulative of what Miss Willis testified, but they could be impeachment. It just depends. And so I'll go through all of those witnesses, Judge, as far as our belief that they have personal information. How I sort of categorized them was we had Willis, Sonia Allen, and Dexter Bond, and then Daisha Young.
All people from Fulton County.
Sonia Allen is the head of the anti-corruption unit.
Okay.
She's the one that essentially started these contracts for all of these anti-corruption contracts, which is where most of the outside counsel work in the DA's office is coming from. She has personal knowledge about the relationship between those parties, about the financial benefit, about the contracts. She's the one that is the head of the anti-corruption unit. And, you know, just to focus in on whether or not we have to talk to a witness before we subpoena that witness, there's no law that says you have to talk to a witness before you subpoena them. And that makes sense. Police officers regularly do investigations and they talk to tons of witnesses. You talk to one witness and it leads you to another witness. And you subpoena people who are not particularly willing to talk to you. I asked all of these people to talk to me. It's not surprising that they don't want to. They also all have NDAs. So they have non-disclosure agreements that they've been asked to sign by the district attorney's office. And so they're hesitant. And I'm not saying these in particular, but members of the district attorney's staff are hesitant to talk because of that. But a court order, such as a subpoena, would alleviate any of those concerns.
So recognizing that, even if you don't have to talk to them, I think you would still have to have some kind of good faith belief of what it is they could possibly say that is relevant or that you could later impeach them on that then becomes substantive evidence, right?
Yeah,
Right.
low standard.
So what is it? Let's just start with Miss Allen. She
Okay.
starts the anti-corruption unit. She may have been there at the formation of these contracts, but is there anything as part of that that you think plays into these issues?
Just personal knowledge as to when the relationship started. These witnesses would all have personal knowledge as to when the relationship started.
And when we say the relationship, are we referring to just the fact that they knew each other, or that they knew that it changed or evolved?
That it was that the relationship predated Mr. Wade being hired as special counsel.
And
romantic.
what aspect of the relationship?
That their relationship was romantic, Judge. I'm sorry. I should have been more specific.
Sure.
So these witnesses all have personal knowledge. And I've talked to a lot of different witnesses. And a lot of witnesses, when you're investigating a case, some witness may not have personal knowledge, but they might know someone who does have personal knowledge, things like that.
Understood.
The-
How do you know Miss Allen has personal knowledge of that?
From Mr. Bradley.
Okay. All right. And so
Okay.
theoretically, if Miss Allen testified and denied that, Mr. Bradley would be able to impeach her?
Right. Yes,
Okay.
Judge.
All right.
And the same with the other witnesses, Ms. Young and Mr. Bond. Yes.
Is that the same argument? Nothing else to supplement that or to add?
No, not for those, Judge. There's a couple other witnesses that we included. One of them is so Robin Yurdy, who we'll get to in a minute, was Miss Willis's executive assistant. I subpoenaed her current executive assistant, which is Tia Green. That's her personal assistant who keeps her calendars, does all of her scheduling.
All the
She
vacation
can testify
time,
as to travel that they took together, spending, different information about spending, and then also the personal nature of the relationship. And then the other all of the other folks are.
Well, we're moving on. So that was Allen and Young. You'd lumped Bond into that same initial category. So what about him?
Yes, I did. I'm sorry, Judge. I lumped Bond, Young, and Allen into that same. Basically, I lumped the lawyers, Willis, Young, Allen, Bond, and Wade, all together as far as personal knowledge of when the relationship began.
And although, again, just focusing on Allen, Bond, and Young, although you're saying you don't personally have statements from them on the record or in some kind of documentary form, you're saying that if they deny knowledge, you have someone who can impeach that testimony.
Yes, Judge.
Wow.
All right. Okay, let's move on to the next category if you've got one.
Tia Green, that's the executive assistant. And I'm sorry, I jumped ahead on that argument. Miss Green replaced Robin Yurdy, who is the former executive assistant, essentially does calendaring, keeps calendars, things like that, and can attest to when travel was made. Some of the things we've got travel documents that we have to admit in other areas, but this would put Miss Willis with Mr. Wade on these trips.
Busted.
And again, we don't know what Miss Green would say, so
Right.
is it just the fact that she keeps the calendar that you assume she knows that she's going with Mr. Wade?
Right. Well, that she knows that she keeps the calendar. She's her personal assistant. And so Miss Yurdy did that before, and Miss Green took over that job.
But other than saying, it's possible Miss Green could just be saying, yes, she was out of the office this week, and that's all I know about it.
It's possible she could say that, yes, Judge.
And do you have any evidence to suggest she knows more than that?
Not specifically, no. And she has unfortunately not been willing to talk to me.
Understood. So that seems that like there's less there for you to work with.
There's definitely less there for me to work with, yes.
What else do you think I got to know about Miss Green then?
With Miss Green, it's really, so Miss Yurdy was the one who had this type of relationship before, and Miss Green took over that role, that personal assistant role. And my investigations revealed how Miss Yurdy knew all of the travel arrangements, purchasing, things like that. And that's what led me to Miss Green.
Okay. So just following,
All right.
following the data, you have to follow the bouncing ball on the very specific bits of data. Okay. What does this person know? Why are they valid? Why should I hear from them? And so on. And so they're bouncing around right now, but remember there was a bunch of people they subpoenaed. And so they're continuing on.
So the other area, all of the other folks for the DA's office are people in security, essentially, investigations and security. They are people who have served as the personal detail for Miss
This would
Willis.
be Hill, Green, and Ricks, right?
Yes, Hill, Green, and Ricks. And those folks have served as Miss Willis's, she calls them the head of dignitary services. It's essentially the team that follows her around and takes her places. And they would be able to testify, from the witnesses I've talked to, they would be able to testify about she and Nathan going to the safe house together, living at the safe house together, staying there regularly, things like that. Cohabitating, essentially, which disputes what is in the affidavit.
But I guess if you're referring to maybe a specific date or time frame, you don't know which of these three witnesses, if any of them, might personally know about that time frame or could.
I believe all three of them do. I believe
Okay.
all three of them know about that. I've spoken with other people who were formerly on the dignitary services who did not do that and who identified who are the ones that actually would have that direct knowledge, actually did the transport of Ms. Willis and Mr. Wade.
And so if either of these individuals came and denied having any knowledge whatsoever, you have someone who could impeach them having made a prior statement explicitly on that point?
Yes, I do.
All right, what else?
I think the only other issue for the district attorney's office was the bank records. I don't know if you wanted me to go ahead and go into that now or wait for Mr. Evans to talk about that. The state had.
Right, no, I think we'd want to loop him in on that. But let me just, on this first issue, allow Ms. Cross to jump back in. And so, Ms. Cross, focusing.
All right. So huge points there by Ms. Merchant, and did a great job of really fleshing out all of the big issues that we need to talk about in this case, going one by one through all of the various witnesses that they had subpoenaed. And of course, they're objecting to each one of those subpoenas, trying to stop really any testimony, including Nathan Wade and Fani Willis. And so it sounds like the judge is hinting towards allowing them in, right? Allowing the subpoenas to be valid because she was able to articulate a reason, a rationale for each one of those individuals. And she did a great job. Very fun to watch that.
Solely on whether defense counsel has made a good faith basis to show that the relevance of these witnesses, even though, she may not have talked to them or they didn't want to talk to her. Why is Quash still appropriate?
Quash is still appropriate here because even Ms. Merchant's recitation to the court of the facts and circumstances of why these witnesses are relevant displays a misunderstanding of the role of these individuals, and in particular, the role of Ms. Yurdy. Ms. Yurdy was never part of the executive staff or team. Ms. Yurdy was not someone who kept the district attorney's schedule or calendar.
What'd she do?
The allegations here are she worked on the media team was her role. The media team, not the executive staff or team or responsible for calendaring the district attorney's office.
But just to be clear, your motion doesn't cover Ms. Yurdy. That's
it doesn't. It doesn't.
But you're saying that impacts the argument towards Ms. Green? Okay.
Correct.
All right.
Correct. And the other individuals, Ms. Merchant didn't make a representation to the court about how Mr. Bradley would know about the knowledge of Ms. Allen, Mr. Bond, and Ms. Young. That is, I think, relevant information. If it's not admissible, any impeachment evidence she has would not be admissible. Likewise, the security.
Why wouldn't it be admissible?
If Mr. Bradley heard that second or third hand that Ms. Allen knew this, or Ms. Young was aware of that, or Mr. Bond said this
Sure.
to someone else.
That wasn't the impression I got. The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about specifically?
Well, essentially, that kind of seemed to be all of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
All right, Ms. Cross.
Wow. Okay. Wow. Okay. So we're talking, about hearsay. Anna is looking flustered right now. She's looking a little flustered. So Bradley is Wade's law partner, and apparently he's got direct inside source information about all of the other witnesses, right? So she was saying, like, direct one-on-one. In other words, Bradley heard it from those other people. So it's not hearsay, right? He heard it. He can come in and say, I heard that. And this is what happened. Now, Anna was saying, that he heard that stuff from other people, saying Bradley is going to come in and say, I heard that from someone who told me that, but about that other person. But, Merchant just came back up and said, no, direct, all of them.
We'll be shocked.
I'll be shocked.
We'll be shocked.
We'll be shocked.
If Ms. Merchant is able to support that statement. Shocked.
Shocked. shocked.
I don't believe that's true. I don't believe, even if it was true, and it's not, and can I just say, when we're talking about the timeline and what might be relevant in an evidentiary hearing, there is, I guess we could spend a lot of time talking about dates and timelines and who is responsible, but for the record, and should there be an evidentiary hearing, I understand the court's ruling, there's an evidentiary hearing. What the state will establish with unequivocally is that there was no cohabitation. District Attorney Willis and Nathan Wade never lived together, that the representations that have been made.
Okay, so that's, you got to be careful with that. Like, lived together. Like, okay, they shacked up together. They went on cruises together. But like, what does living together mean? Like, did he have his bills go to her house or something? Like, is that the standard that they're, we never bought a mortgage together. It's like, okay, we're not talking about that. Like, did you sleep over regularly? Was he there often together? Like, were you in and out of the same location on multiple nights in a row? Okay. That's living together, right? That's waking up, doing things together, and living together. Maybe not permanently, but it's cohabitating at least, right? If that's the standard. So what is the standard? And what she is hinting at, right? It sounds like to her, like this Bradley guy she makes it sound like it's a strong state witness, right? In other words, he's going to come out here, take the stand, and deny everything, or invoke, right? Plead the fifth or something, and I don't know. Maybe he's sleeping with somebody too. Who knows? I don't know what's going on. But the point is, like, she thinks that he is not going to say what Ashley says. So maybe, she heard something from Nathan Wade. Maybe he promised Wade, like, yeah, I got a subpoena, but I'm not going to say anything, or something. It's weird. Like, you don't know what's happening behind the doors.
To date are just demonstratively untrue. For example, the allegation is that they lived together in District Attorney Willis's home prior to District Attorney Willis's father living with her, and that when the father moved in, then Mr. Wade moved out. Of course, that is untrue, and the state would be able to establish that Mr. Floyd, District Attorney's father, moved in, even changed his Georgia driver's license prior to the time that the District Attorney and Mr. Wade ever met. That the testimony from Mr. Floyd would be that he lived there continuously and never saw Mr. Wade there. The evidence would be that the timeline that's being represented is either mistaken, if that's charitably, or simply fabricated. So I just want the court to understand that this is a hearing that we're contemplating, and I understand the rulings. But to return to your question about Ms. Allen, Mr. Bond, and Ms. Young, I believe that the spectacle of calling opposing counsel to, in this case, deny that they have any knowledge about a relationship, because they didn't have any knowledge about a relationship, and certainly none that contradicts the Wade affidavit. Calling them in to say that, and then another individual to say, no, I heard otherwise, appears to have very little evidentiary value. I will put it that way, even if the good faith basis that Ms. Merchant represents has very little evidentiary value. Insofar as the security staff was referenced and mentioned, again, I don't believe that there is a good faith basis to believe for any witness to say that the two cohabitated. They never did so. I don't believe there's a good faith basis for any witness to say that there was a relationship prior to 2022, as was represented in the affidavit. These witnesses, who have a host of other security sensitive information about the district attorney and her travels and her arrangements and the means by which she is kept safe under the constant threat that I think we all recognize is there, that there is no good faith basis to believe that they have any information. Again, she's never spoken to anyone, and I didn't hear a representation that anyone could impeach those witnesses with testimony that they said otherwise. So I think those are properly quashed even without further inquiry.
In that last bit, you're referring to the investigators?
Yes, sir.
Well, I mean, again, I think that's what Ms. Merchant is putting out here, that her star witness, Mr. Bradley, is able to impeach every one of them. Is that what?
I didn't hear the representation that Ms. Merchant said that Mr. Bradley told her that he has personal knowledge that investigators Hill, Green, and Ricks had knowledge of a cohabitation or a personal relationship prior to 2022.
Ms. Merchant?
Maybe I missed it.
It depends on your definition, Judge, of cohabitation, that they stayed at the same house together, slept at the same house. Yes, that they have knowledge of that.
And again, knowledge based on statements that they made to someone else who you do have under subpoena and you would intend to have testified at the hearing.
Yes, and Judge, just for background, when DA Willis took office, Mr. Bradley had a contract. So did Mr. Campbell. They all had contracts. The whole firm, there were three partners. It was Bradley, Wade, Campbell, a three-person firm. They all three had contracts to work at the DA's office. So they're all working at the DA's office in some capacity. Two of them had these taint contracts. So Bradley he had two contracts actually. He had a first appearance contract.
A lot of taint
So did
going
Mr.
on there in
Campbell.
Georgia.
And Mr. Bradley and Mr. Campbell also had these taint attorney contracts where they're working directly for the anti-corruption unit. So it's not just this lawyer that he's partners with out in Cobb County. They're all together. They're all intimately together.
I mean, that's good by way of background, but really, I just think just to get through over that threshold today, and Ms. Cross, I'll let you have the last word here, but I don't know how many times, or you may have argued at a closing the pattern instruction that a single witness, if believed, can establish a fact. What I'm hearing is again emphasizing the conflict in the evidence, and if the state it sounds quite confident that it's going to have an abundance of evidence to show these things are not true.
Yeah, she's got evidence to show the opposite. So it sounds like you got a lot of stuff. You've got this guy, this witness, dad's going to come in and say that's not true, and mom's going to come in, all these people come in. Okay, but it sounds like there's a conflict. So we actually have to have a hearing to debate those things.
But I don't see how I can make that determination on the front end without live testimony subject to cross-examination and an assessment of demeanor and everything else that goes into those kind of determinations. I don't see a way around that. Any final thoughts for me?
Only, Your Honor, that I'd ask the court to hold or reserve ruling on the state's motion to quash until Mr. Bradley, who appears to be the sole and primary source for the allegations that have been made, until he testifies at a hearing. And then if you're not otherwise inclined to quash the subpoenas, that they be revisited at that time.
All right, I think that is appropriate. So to that end, one thing I would share is that obviously, as we talked about, the rules of evidence would apply, but this is much more so than I would do in front of a jury. I plan to be proactive about the application of 403 and 611. And so if there's anything that's cumulative, if there's anything that is referring to, as in the words of the rule, harassment or undue embarrassment, I'm not going to feel inhibited from stepping in, even without an objection from counsel, to move this along and keep it focused on the issues at hand. So to that end, I do think that, again, under the court's authority to control the order and manner of presentation of the evidence, it would be important that from the outset, we're not talking about calling Ms. Willis as the first witness, and we need to get over a few procedural hurdles before we can get there. So I agree with Ms. Cross on that point. So, however, when it comes to the issue at hand, I think Ms. Merchant has established a good faith basis for relevance, and I don't see how quashal can be imposed here.
Yeah. Fani, your subpoena is still active. Get your butt ready for court on Thursday. Hopefully you and Nathan have a nice Valentine's Day steak planned out. You're going to need your energy. So that's the judge saying, look, I'm not quashing Fani's subpoena, okay? There's a lot of problems that I just heard about in this case, and it sounds like Ashley's going to at least be able to get us over the hurdle. But Fani doesn't have to go first. Fani can go second or whenever the appropriate timing is, but they're going to start off laying foundation, right? They're going to bring in Bradley. He's going to come in and say, yes, I can point to this. Yes, I can point to this. I have personal knowledge. It's not hearsay. It's all relevant, right? Whatever. It's all material. And then once he starts, pointing out certain people, then they can call them in. So Fani's going to be on a hot standby, ready to come in and testify. And they are not happy about that. Woo!
I think it's a closer call with Ms. Green. That may yet result in quashal, but at this point, with each one of these witnesses, I would defer the ruling until we get further into the hearing itself. All right, anything else, Ms. Cross? I know you had also talked about the bank records, and as it relates to the privileges with Mr. Bradley, I think those just need to be handled as the questions are put to him. And if it needs to go into an in-camera session, we can do that, but it sounds like Ms. Merchant is aware of that issue. We would need to establish when and how and the scope of his representation of Mr. Wade, and we could proceed very carefully to make sure that issues of privilege are not gone into.
Thank you, Your Honor. Of course, Mr. Evans will speak to the bank records insofar as there is a privilege. Again, Mr. Wade does not waive any portion of it, and if that could be a conversation that takes place in chambers as opposed to in open court, I think that would be beneficial for everyone.
All right.
I'm sure.
Let me turn then to Mr. Evans. I think it did join us by Zoom now. And
can you hear me, Your Honor?
I can, there's a bit of an echo. Give us a few more.
Say something else, Andrew. You're frozen.
Is that better?
That's much better. All right. So having reviewed your motion to quash and the reply, and with the benefit of what you've just heard before, my remaining concern deals with scope and overbreadth. I think the subpoena is pretty broad there. So maybe we could start start with that, Mr. Evans. Anything else you'd like to add?
Yes, thank you, Your Honor. The scope is not just overly broad, it's limitless. It requests any and all documents in Synovus Bank's possession related to Nathan J. Wade, Nathan J. Wade PC, Nathan J. Wade PC, and or Wade, Bradley, and Campbell law firm. So there's no dates given, no scope is provided, no reason requesting these documents is mentioned, and no connection to the criminal charges against Roman is cited. So you mentioned a reply. I have not seen any reply file.
Oh, well, you missed it. You missed it. It was really good. We just read it in the prior segment. It says that your client is a liar.
I didn't file one on his.
Okay. I suppose it didn't relate to your specific motion to quash. Let me just start right there. There's no date range whatsoever in this, Ms. Merchant. Why is that not quashable just on itself?
Judge, and if there's no date range, then we were supposed to have certain records. So I've already received most of the bank records. I need a business record certificate, which is what I sent with the subpoena, because I cannot admit those records at a hearing without that business record certificate. The records I have end in November, I believe. They're voluminous. And I wanted to be able to do a summary under 1006 for the court, because I agree, I don't want to go into tons of bank records. I don't think, 98% of them aren't relevant, but 2% are. And so in order to get them into evidence, I've got to have a business record certificate. I had to subpoena the banks to get that business record certificate. I've got the documents I've got a business record certificate that was filed in the divorce case, but I don't have one for this case. So, and the one that was filed in the divorce, or the one that was received in the divorce case, I believe ended in November, those records. So that's why we need these.
So the only thing you're after still, you're saying is for Synovus Bank to have signed a certification.
Yes, Judge.
All right. So just a kind of a sub issue here. What authority do you have that someone can be subpoenaed and forced to authenticate a document?
They can't be forced to authenticate the documents so that they authenticated in the Cobb County case. And it's
Or even the ones they produced. Well, they haven't produced any in response to this, right?
No, they have not.
You're saying you've got what you need already from the Cobb County case.
Right.
And you need a further record certification for what exactly?
So I have the records that were submitted under the business record certificate in the Cobb County case. That's a civil case, so it's a little bit different rules, but not major different rules because of business records. So I've got that business record certificate. They certified those records. I've got that. But I wanted one for this case, a business record certificate for this case. So that
You just want a different case number on the business record
Well,
certification.
it's the same records. I mean, I did not anticipate this would be a big deal.
Why do they need a different case number? Why wouldn't a business record certification for another case apply in this one?
I was just being overly cautious to try and get it because I anticipated an objection to that because they were certified in that case. If there's no issue with that, then I've got the business record certificate.
Well, I won't rule on it proactively unless I see whether there's an objection from the other side and what argument they have on it, and that would be up to the state. But to the original point, even if you've subpoenaed someone for a business record certification, is that an appropriate use of a subpoena?
I would bring them here to get the records because if I don't have the business record certificate, then they have to take a stand and I get them in that way. So that's why I subpoenaed them.
So they are, the bank itself is a person has acknowledged subpoena from from the bank.
Yes. I talked with the bank. The bank actually has a lawyer and they don't want to come to court. They want to submit a business record certificate.
Right.
And I don't have any problem with that. Like I told them, I just need that in advance of the hearing so I can put the state on notice of.
All right, Mr. Evans, having seen that the scope of your motion to quash is very much a more narrow focus than perhaps we thought, any reaction?
Well, Synovus refused to produce the records pending the motion to quash. So I don't know about they haven't agreed to produce anything, but what is the purpose of trying to get the personal and law firm bank records? What is the goal here?
Oh, well, that's because, I'll let them answer it. But one reason is because they said that they split bills, right? That they split costs. And we have a lot of questions about that. We don't think that they did. We think that they're liars in their filings.
That's part of what's overly broad about this is not just that there's no dates, not just that there's no scope, but there's no connection to the underlying crimes charged against Roman, neither alleged nor could there be. Like, what are we hoping to even discover here? Number one,
has this dude
how would
read
that be relevant?
Anything?
Number two, and just what is the general purpose of all this? I mean, keep in mind, this subpoena went to Synovus. It never went to my client. Ms. Merchant hid it from my client. We only knew about this because Synovus properly and timely alerted us of the subpoena. So all of this was meant to be kept outside of our knowledge. So it's done in secret. It's done in a way that has no limit whatsoever.
It's a defense
on it,
investigation.
it's done with no reason mentioned. So what is the goal here?
Sure. Okay, Mr. Evans. And so I'm clear, the subpoena is not just the law firm records, it's also Mr. Wade's personal bank account records. Is that right, Ms. Merchant?
Personal bank account records at Synovus. It's law firm records.
Okay. So other than maybe showing or proving how much money the law firm received as a result of the representation, why do we need these?
It's not that, he actually paid for most of the trips out of the
Yeah,
law
it's
firm.
trips.
So that's why. He paid for personal trips that he and Ms. Willis took.
Out of his law
firm.
firm.
And there's quite a few different bank accounts, which is why I don't mean to sound vague. It's just there's a couple different bank accounts, and I have all of the bank records, and we put a lot of that in our motion, our response, so that the court would have some specifics as to the money that was spent. But essentially, the money's being spent on Ms. Willis. Some of the money is being spent on Ms. Willis.
Not
and
law
so it's
firm.
relevant to show that she has a personal or financial interest, which is the entire issue of disqualification. So the hearing that we subpoenaed these records for has nothing to do with the guilt or innocence of Mr. Roman.
Yeah,
You don't have to address that.
Evans just got blown out of the water. What the heck kind of question? He's like, why are we here? What does Nathan Wade's records have to do with Mike Roman's guilt? You're like, dude, do you know what hearing you're at? This is not a trial. This is an evidentiary hearing on a motion to dismiss and disqualify. So not good.
Okay.
But I guess going back to the core point here, the subpoena at issue did not have any limitation on time.
And Judge, and I apologize, I already had the records, and so I wanted them to certify the records. I did not anticipate it would be an issue like this. And so I normally, when you serve a subpoena like that, they would contact us, and which they did. And I actually reached out to them to try and narrow this issue. I did not assume that it would turn it. I didn't mean to hide the ball on the dates or anything like that. Like it's the records we have that I wanted certified.
Well, I think we can't amend it after the fact, and so you can try to reserve it, I suppose, before Thursday. But the subpoena in front of me, I think, goes too far, or you can try to use the record certification you have elsewhere if you think that's
That's what I can just do that, Judge. And we did file the returns, so I mean we're not trying to hide anything.
Sure.
The returns. That's I believe how they got them.
All right, Mr. Evans. So I'm granting your motion. Anything else you think we need to address on your behalf?
No, Your Honor. Thank you.
Okay, so
thank you for
so he's actually successful. He doesn't even read anything. He just goes in there and says, well, she says, I'll try to get it in another way. I already have the business certificate. And, you know, this type of stuff is necessary in order to get records admitted into evidence. You can't just come up with like a bunch of printed out documents, right? And say, here, these are legitimate. What's the foundation? Are they accurate? Are they authenticated? And so when you slap a business certificate on there, you say, okay, these are records that are kept in the ordinary course of business because they're part of a business. Here's the business certificate. And so it's just some procedural stuff that she's got to hash through. And so I'm sure she'll figure it out.
Joining us.
I am, Judge. Good afternoon.
All right. Good afternoon, sir.
Gabe.
Any particular order you want to go in?
I can address mine first, Judge. I mean, I'm sure the court has read the pleading. Ms. Merchant actually filed a response. I mean, in my pleading, as it concerns my motion to quash, you know, of course, I represented that I have no personal or direct knowledge concerning the issues that are germane to this court or that are pending before this court. I mean, taking a glance at what the court has already discussed with Ms. Cross in the state's motion, I would submit that, I mean, if she's saying that I have relevant information and that at some point she has a witness to reflect that I have direct or indirect knowledge concerning the issues that are germane to this court, then, you know, I guess we would just have to wait and see. I would submit to this court, however, that I don't. And I mean, it is a fishing expedition as it concerns me. I mean, I guess arguably, if she wanted to question me about whether I was considered to be the special prosecutor, that certainly would be relevant. But based upon my lack of knowledge concerning any romantic relationship prior to her motions and the issues brought out before this court, I have no direct or indirect knowledge. And so I do think it's a fishing expedition. And of course, if she wants to respond and suggest that she has a witness that will contradict that evidence, then so be it. We can just deal with it at that time.
Okay. And I'd note, Ms. Merchant, that if it's solely to say that he was considered to be special counsel as well, special assistant, that's going to go more into the qualifications area that I don't see as germane and necessary for an evidentiary hearing. But over to you.
I think what Mr. Banks was kind of suggesting was that he sort of be like in waiting, you know, like sort of a backup. And that's what I planned on for him anyway, as far as some of Mr. Bradley's testimony.
Sure. But I'd also he has other clients and other obligations. And if there's really nothing of relevance, then I think we need to at least have some kind of, as we did with the other witnesses, an initial upfront showing of that. So as we walked through just at a surface level with the district attorney employees, what is it that Mr. Banks you think is going to testify to that that you're going to be either able to, he's going to go along with you, or that you're going to be able to impeach?
It depends on how they impeach Mr. Bradley. So he would be, there's some areas that they may question Mr. Bradley about, and Mr. Bradley has received phone calls from some people over the last several months trying to promote him not to testify.
Wow.
So I don't know what the state plans on going into.
Wow. Wow, that's spicy. So Bradley might testify to say that he's got a bunch of people calling him to say, don't testify at the hearing. Who may have called him? Could it be Gabe down there?
Well,
let's watch if Gabe flinches. Let's watch if Gabe flinches on this one. Let's see.
Calls from some people over the last several months trying to promote him not to testify. And so I don't know what the state plans on going into.
Cold as ice, man. Nice poker face there.
Well,
Gabe.
And I can
cold as ice.
Appreciate the need not to want to have to present your entire case today, but at the same time, I think we may need some more specifics, and if that has to be in camera, then we can do that.
I mean, it's just Mr. Bradley has received calls that he believed were trying to keep him from testifying.
All right, and those calls would be relevant and admissible how?
It depends on if he is cross-examined about it, but it's also his fear in testifying. I mean, that's something that the state regularly asks witnesses if they want to be there to testify. You know, if they to the veracity for the court. You know, he doesn't want to be part of this. He doesn't want to come and take the stand. And so I think when he goes into that, it'll be relevant to the court.
Is your contention that Mr. Banks made some of these calls?
Great question.
All right.
The question was yes.
Mr. Banks back to Mr. Banks made some of these calls?
Yes.
Oh!
Okay, Mr. Banks, back to you.
Banks!
I mean, to the extent that I had conversations with Mr. Bradley about it, I mean, there's certainly conversations that I had. I called him, and I'm happy to talk about it, but I called him on a personal level because, one, he's my friend, and two, he's my fraternity brother. And I know that ultimately these type of things are very stressful. I was concerned ultimately about him being emotional given his prior relationship with Mr. Wade, of not being able to see the forest beyond the trees when you actually are making decisions on an emotional basis. And based upon my understanding that he had represented Mr. Wade dating back as far as 2015, notwithstanding the fact that the divorce proceeding wasn't filed until 2021. It's my understanding that I was concerned personally as my fraternity brother and as another member of the bar that he might arguably be running afoul of the attorney-client privilege. And so I did have a conversation.
Wow. Oh my goodness. This dude has the stones to show up to this proceeding and to just basically mock this proceeding. I don't even know what I'm doing here. This is ridiculous. I have no involvement in this case at all. If she's going to call me, I have nothing to testify to about it all. And she says, yeah, you might have called him, and literally he's like warning him, like attorney-client privilege. Like, if you breach it's an implied threat, okay? If you breach your attorney-client privilege on this matter, you might lose your law license, right? You might lose your bar license. I'm telling you, man, these county attorneys are very, very powerful, and they don't play around. Like, you know, they use their power, many of them, not all of them, corruptly. Some of them do use it corruptly to put pressure on things, to, you know, go send, you know, cops just kind of do laps around your house or something. You know, they exploit their positions. This guy has the stones to come here and say he's got nothing to do with any of this, and then he's outed as literally calling to dissuade the key witness from testifying. Unbelievable. Then he admits it in open court. How dumb can you be? They just keep digging themselves into holes. It's wild.
With him about that and just express my concern.
Because they're fraternity
bros. That was a way to intimidate. If that's what he's suggesting, I mean, I would take issue with that. And in fact, we laughed, and he said we need to get together for a drink afterwards. And
wild.
So, but if that's what she wants to call me about is my conversation with Mr. Bradley, I'm not sure that's relevant.
We'll see it.
Sure.
We'll see in court.
Okay. Well, and I think that sounds like something that's just, we're going to have to see as the hearing
we'll see in court.
begins and what we get through as to whether it becomes relevant.
Yeah. See you there. Wow.
it becomes an issue. And so I don't think your motion would be able to be granted today.
Sorry.
But we'll see. You can re-raise it at the hearing if you think it's necessary. I also think, I would imagine you may have other, if you have other conflicts Thursday and Friday, I don't think it's necessary to have you waiting outside the courtroom for those 2 straight days. So we'll just put you on a 2-hour call if that works.
Crazy.
Well, the only conflict for the court's awareness is on the 15th, I have to be in federal court in Macon.
You going to cruise?
And so to the extent that you could get to me on one of those other days, that would be great and preferable, but I have to be in federal court in Macon at 1 p.m.
Well, we'll be in touch about any logistics. So as it relates to Mr. Campbell.
Wow.
And
That did not work out well for that dude. Oh my gosh. I have not seen a crash and burn like that in a while. He came here with a lot of self-assuredness. I don't even know what I'm doing. And then he just got obliterated. Unbelievable.
I understand on the front end, is it a similar argument? I know you've raised
a similar argument to Mr. Bradley, Judge, and based upon the court's earlier kind of discussion and colloquy with Ms. Cross and Ms. Merchant, I'd assume that they're not trying to go into attorney-client privilege. I will just take issue. I mean, it seems to Ms. Merchant's response seemed to suggest that because he wasn't counsel of record in the divorce, that somehow or another he hadn't gleaned information that was related to the attorney-client privilege. My understanding is that Mr. Campbell or Attorney Campbell joined the Wade law firm back in 2012, and that at or around 2015 is when the issues concerning whether or not Mr. Wade was going to get a divorce with his current wife came up, and that the firm began to represent him at or around that time. And so to the extent that she's seeking to get into information concerning what he gleaned, albeit not a counsel of record, but a member of that firm, that I would submit that would certainly be an issue that we would be seeking to avoid him testifying about.
Ms. Merchant, any response?
Judge, I wanted to make sure that I'm clear. There was also some allegations in Mr. Banks' petition that they were business associates. And so that I don't know if they were arguing there was some type of privilege. I can't find anything to indicate that they're business associates. And I couldn't find anything to indicate that Mr. Campbell ever represented Mr. Wade.
Isn't the firm Wade and Campbell?
Yeah, but they're not. But if you go to the bar website, it's not. And if you go to the Secretary of State, it's not.
Wow.
And to further complicate matters, Mr. Campbell has a taint room conflict contract right now, and has had it for the entire time Ms. Willis has been there. He is doing taint review under Garrity for Mr. Wade's anti-corruption unit. So I don't think they are partners, because I think that would be problematic for them to be doing taint review of privileged material.
What is happening? They're not, okay, so when you form an LLC, you have to list the members who are on the LLC, member manager, who's a part of the business, the lawyers. These are lawyers. Wade, Campbell, and whatever. They don't even form their law firm with the same people on the... What the heck is going on? It's like a bunch of people who've never practiced law before. And they can't be partners because they have similar contracts. In other words, if they're partners, the guy who's doing the taint team review is apparently partners with Nathan Wade. And he's not supposed to be partners with Nathan Wade because he's supposed to be doing the taint review. Separate and apart from the rest of the people. What is happening?
That is being reviewed by.
Well, I think with those red flags, I think that's also worth noting that we've got 2 witnesses here, Mr. Bradley and Mr. Campbell, where privilege issues are being waived. And I think to the extent possible, we could burn hours getting into these issues. So I think we're going to have to be ready to address those efficiently in determining the scope and manner of the representations, or save them towards later in the presentation of the evidence. So, Mr. Banks, any initial, just on that last point about, is there any privileges as it relates to something related to their business association, or is the sole focus that may come up if he's called to testify relating to the attorney-client privilege?
I used the word business partner because he is,
on the
they
firm.
are partners.
You probably didn't know that.
Time, whether they were partners way back when they joined the firm, back when he joined the firm in 2012, I don't think that was the case. Having said that, to the extent that he gleaned confidential information through the attorney-client privilege while being a member of that firm, it would be much like a paralegal wouldn't be able to, divulge privileged information while working ultimately with that firm. Now, that's as it concerns any information that he gleaned concerning the relationship between Mr. Wade and Ms. Willis during the pendency of the divorce proceeding. And prior to the pendency of the divorce proceeding, frankly, I don't think that the attorney-client privilege starts when someone files an entry of appearance or files a complaint for that matter. I think
Sure.
attorney-client relationship.
All things we'll have to get through.
Yeah.
All right, but for today, I think there's at least that basic threshold showing of relevance where we may end up having to be called at this hearing.
Yeah.
So
See you there, Gabe.
I'll defer ruling as the record develops. You can re-raise it.
See you Thursday, Gabe.
All right, thank you, Mr. Banks. If there's
All right,
anything-
thank you, Judge.
All right, take care.
All right,
I think we still have Mr.
turn
Partridge
that
and Ms.
camera off.
Monroe. So let me turn to
That was a disaster. That guy had
Mr.
a
Quash
bad
file on
day.
behalf of
Bad day.
Ms. Yurdy.
Hi, good afternoon, Judge. Durante Partridge on behalf of Ms. Yurdy.
Yurdy.
Yes, sir.
What's
So
up, Durante? On behalf of
it
Yurdy.
probably makes more sense to start with Ms. Merchant.
Yurdy is, of course, the former employee who used to work for Fani.
On this.
Yes, Judge.
Yes, Judge, that's fine. Judge, Ms. Yurdy owns the property that Ms. Willis was staying at. She has an immense amount of knowledge that's relevant to this case about their relationship prior to Mr. Wade being appointed. In this case, they've been best friends since college for 30-something years and has knowledge of the relationship. The relationship prior has knowledge of them staying in the apartment. She owns the apartment. So.
All right. All right, Mr. Partridge, in light of this conflict in the evidence over the relationship, what do you think the grounds would still be for quashal at this stage?
Yes, Judge. Thank you so much. First and foremost, just to clear discrepancy with what Ms. Merchant just said, my client does not own the property whatsoever. She was leasing the property at the
My
time.
partner. So is he representing his wife?
And subsequently moved out
Or
of the
business
property
partner.
to move into another property that she was renting as well. And Ms. Willis continued to reside at the property. So my client did not know anything that was going on at the property when she moved out. So just to clear that first and foremost, Yana.
And I'm sorry, Judge, rental. It was a rental. I said owns and I meant leased. So had authority over the unit. Sorry.
All right, Mr. Partridge.
Thank you, Judge. Furthermore, Yana, with regard to this situation, we called it a fishing expedition as well.
That's what
merely
they all
because
say.
Ms. Yurdy does not have any information as it relates to that of a romantic relationship or any relationship or what took place at the property after she moved out. I've communicated that information to that of Ms. Merchant from that of Ms. Yurdy, so she just has absolutely zero else to add to.
Okay. Ms. Merchant, do you have anything that would impeach that testimony if that's what she testifies to at the hearing?
Yes, she has personal knowledge of their relationship.
And how would you impeach that?
I can impeach that with Mr. Bradley, but I believe that Mr. Yurdy will testify truthfully, and I believe that she will tell this court that she has knowledge of their relationship and has knowledge that Mr. Wade was staying at the apartment that Ms. Willis was staying at.
Okay, Mr. Partridge, back to you.
Yes, Judge, I would disagree as it relates to the representation that Ms. Merchant made. If there's any information or testimony that Mr. Bradley has, we'd also ask the court to reserve ruling as to Ms. Yurdy's involvement with regard to this particular situation to see what information
So
comes
Bradley
from
will
Mr.
come
Bradley.
out and blow the lid
Otherwise, Your
off.
Honor, this would be a fishing expedition because there's no information that Ms. Merchant has stated to the court that would suggest that my client has actual knowledge of a personal or a romantic relationship or Mr. Wade staying at the that particular residence with Ms. Willis.
All right. Well, just a matter of logistics here. Are you suggesting that Mr. Bradley should be allowed to go into statements he's heard from your client before she's called? Because generally you impeach someone after they've said something that they can be impeached with, right?
Yes, Judge, and I understand that, Your Honor. My concern, however, is that there's nothing that we've been presented with. There's nothing in the subpoena to Ms. Yurdy that says or indicates that she has, any information beyond that of what Mr. Bradley has said to that of Ms. Merchant, which is essentially all that we have, all that I've been put on notice about is that Mr. Bradley, is the person, or rather before today, there's another witness, a lawyer that has something to say as it relates to that.
Sure. So if Mr. Bradley were to testify as, say, the first called witness that he had a conversation with your client without going into what it was or what the substance was, and that generally that conversation contained information about the nature and extent of the relationship, is that thing going to open your client up to being called?
It potentially would in that situation, Your Honor, but I guess we'd have to get to that point. I'm not sure what information he would have. I've not had the opportunity to reach out to Mr. Bradley, who I know also, Judge, and so I'm not sure. But according to my repeated conversation with Ms. Yurdy, there's no information as it relates to her knowledge because, again, she moved out of the condo or the residence.
Okay.
And Judge, just there's another issue. There's also in our brief, there's also this issue of the and I know we weren't focusing on that, so I didn't highlight it, but there's also this issue of the media statements, all of those types of statements. So Ms. Yurdy, I think this is instructive for the court. Ms. Yurdy was the person at the DA's office who actually had an account to monitor the critical mention media. So Ms. Willis,
she was the media person,
had a contract with a company called Critical Mention, and what they are is they're a media monitoring company.
Sure, and remind me, is your argument just to say that that is a motivating factor in this case and is underlying her forensic comments?
Oh, yes, definitely, Judge. Yes.
Okay.
And Ms. Yurdy is the one that actually had those reports. There were two people that had access to it at first, and Ms. Yurdy is one of those. So she's one of the people that responded to Ms. Willis and would give her these reports and talk about these reports with her. But she also, I mean, the critical information is that this is her place. That
Sure. So understood, and I'm thank you for flagging that. I think that's likely to fall solely within that box of things I don't think would be coming out in an evidentiary hearing in terms of the forensic misconduct, but we'll take it as it comes. All right, Mr. Partridge, thank you for joining us today. I don't believe that I can grant your motion to quash at this time.
Understood, Your Honor. And if I may, just
See,
for the
you're
record,
already
Judge, there
there.
was something else mentioned as well. I believe when Ms. Cross was presenting, Ms. Merchant stated that Ms. Yurdy was the personal assistant and kept calendars for that of Ms. Willis, and that is also untrue, Judge. Just for the record, she was not an assistant, Your Honor. She did styling for Ms. Willis as well as some public relations work for Ms. Willis during her campaign, Your Honor.
So she'll know a lot about what's
Understood.
going on.
Take care, Mr. Partridge.
Thank you, Judge.
reaching out to Mr. Bradley. Mr. Bradley has retained counsel. He does not want people to continue to reach out to him. So I would just please put everyone on notice that he does not want everyone to keep reaching out to him.
Who is this counsel?
It's BC Chopra.
Can you say that one more time, spell for the record?
Well, he goes by BC Chopra. It's Bimal, B-I-M-A-L. His last name is Chopra, C-H-O-P-R-A.
Okay.
And because he was getting calls from people who are understanding this.
Everybody. So everybody's
All right.
calling. Okay. So Bradley has lawyered up. She just said, look, Bradley's lawyered up. And they better wrap Bradley in bubble wrap for these next 3 days. Okay. He better be put in a padded room, stored away from everybody, because a lot of people are going to try to contact him, right? They're already trying to contact him. It'd be really a bad thing for your career, Bradley, if you did this, right? We're fraternity brothers. You know how much I care about you. You don't want to wreck your attorney-client privilege obligations, do you? Keep Bradley nice and safe up until Thursday when the hearing happens.
I think that leaves us then with Ms. Monroe on behalf of the DA's office as well.
Yes, good afternoon.
The Fulton County Attorney. Okay.
Okay, so thank you, Judge, for putting this case on your motion calendar on such late notice. So the reason for our motion to quash is, number one, these documents that were requested have been provided to the defendant's counsel by way of the Fulton County portal. We have
All right, let's go into specifics. I'm looking at a copy of Exhibit A of the subpoena. It's got 7 bullets. Which of those are you contending have already been provided?
So it is I don't know this specifically, but it's our understanding that about the majority of the responses have been provided viewed by defendant's counsel. And if not provided directly through the portal, it has been attached to the various motions as supporting documentation in this case, and also readily available by public information.
That's why you have a subpoena. We need those other months.
Which ones haven't been, though? Because that could still be relevant for the subpoena.
Yeah.
It's our understanding that I don't have that direct information.
Oh, well, go get it. That's what the subpoena's for.
In light of the responses that have not been provided, there is no relevance for the information. We have a criminal case. The things that they're asking for there's no connection. There's no relevance, and the defendant admits that there's no reason in which these documents.
There is. Someone thinks it's relevant. The judge signed the subpoena. Hello.
There was no reason provided as to why these documents were requested, and in order for a subpoena to be issued in this fashion, there needs to be a material reason for the subpoena, and in this case, we do not have one.
Okay, Ms. Merchant, what haven't you gotten that was on Exhibit A, and why is it relevant?
Thank you.
So I have not gotten all of the invoices from Mr. Wade. I started asking for those back in September through the open records, and I got some of them piecemeal. I got a couple others that the state attached to their motion. So the open records officer said I had gotten everything, and then the state attached a couple more. So now I have even more, but there's still a couple that are outstanding. Yeah. So there's several that are outstanding, and we put that in a very detailed pleading and letter to the Fulton County County Attorney. We have not received a single invoice from Mr. Bradley. We do not have a current contract for Anna Cross or John Floyd.
Weird.
And the issue with that is that Ms. Willis made statements that she paid them the same amount of money. The contracts we have for Mr. Floyd, that is an incorrect statement. He was not paid the same amount of money. We do not have either current contracts for either of those folks. We don't have anything about the time off requests. We don't have anything about the reimbursements for Ms. Willis, and we don't have anything in regards to the last bullet point.
What makes you think that travel reimbursements are relevant? Because everything seemed to be personal travel.
No, well, Judge, we're not sure that it's all personal travel, and I don't believe that it is. This is all evidence that is related to us showing that Ms. Willis had a personal and a financial interest in this prosecution. Reimbursements for her travel. We have some reimbursements for Mr. Wade's travel. So are those trips connected? Those were the things that we're seeking. We sought all of these through open records. These are open records, but the county has been refusing to give them to us despite way longer than 3 days. So before this hearing was set, we already were in litigation over the open records violation. These are things we're entitled to. We don't have to show that they're relevant in the open records context.
Sure.
But so then we get a hearing, and instead of waiting for the litigation and them to actually give us the documents for the open records, I have to get them in through a business certificate. So I can't submit an open records. So I cannot submit all of these invoices. These invoices are hearsay. I need a business record certificate. I sent a subpoena to the county asking for a business record certificate. They have to certify the documents they've already given me. Plus, they've got to give me the documents that they haven't given me.
Okay, let's keep making our way down the list. I can see your argument on travel and vacation since that's at the core of your allegations. The last one, though, talking about all hiring and outside counsel, that seems to go more towards what I'd indicated has a lot less relevance for me.
Hiring an outside counsel for...
Just generally, it says any outside counsel, process for hiring bids, payment of outside counsel.
Are you talking about... And I just want to make sure...
The final bullet. Any and all course.
Oh, okay, I understand. I want to make sure because I printed theirs out right before I left the office. This is in regards to a Board of County Commissioners meeting that was held in November 2023. There was a very detailed conversation between Dexter Bonds and I can't remember her name, but she's the purchasing director for Fulton County. They had a very detailed discussion and said that there had been a problem with the processing of invoices with the district attorney and that they had to talk with her and go through a new rebidding training with them because essentially they were having services that weren't going through the proper channels. We believe that these documents are relevant to show the personal financial interest of the district attorney.
How so?
Getting things paid for without approval.
Okay, so that's going more towards the approval aspect of it and the, maybe county, what you would refer to as, impropriety and sticking to county regs. Is that fair? Not
necessarily county regs, but also sticking to the statute, which is the basis for all of this, the statute that was not followed, which is the basis. But also what are these, is she having a personal financial benefit to this prosecution by submitting invoices and things like that?
$30,000 a month, yeah. It's all got to start
I just want
somewhere.
to add and just provide further clarification. It's our understanding that pursuant to the subpoena and the information that's being requested there in our possession, Fulton County Attorney's Office, all of that information has been provided. But in terms of the open requests that were submitted, the separate open requests that were submitted to the District Attorney's Office on a separate open records request, we wouldn't have personal knowledge as to what requests have been fulfilled or not. But in terms of what we have in possession in our office, we have that information has been provided already.
Standard process
by the District Attorney's Office.
We gave them
so
everything.
there's nothing outstanding pursuant to this subpoena that we would have that they don't have access to already.
Okay, so just to be...
I don't have anything authenticated. I haven't received one single authentication from them.
And I think that's what it comes down to. She's seeking authentication. We just want to make sure that we are fulfilling our end. And if this is information that she has already received, by abusing the legal process with subpoenas just to obtain authentication is not a proper use of the legal system, nor is it coupled with the fact there is a pending litigation, as Ms. Merchant so emphasized, pending against the District Attorney's Office regarding an alleged Open Records Act violation.
Well, how else would she authenticate it then, Ms. Monroe? Are you planning to come down?
Yeah, what are you going to do? Are you going to go
and have someone personally?
That's your job.
Testify to it?
Without a subpoena?
I'm sorry, I didn't hear the question.
Well, I mean, more to the point, it seems this conversation keeps shifting. It's either the county attorney does not have the items requested, or is the sole issue now just authentication of the items that she already has, the defense already has?
Your Honor, may I be permitted to speak? This is Shalonda Miller. I am the designated records custodian for Fulton County.
Okay.
And I might be able to provide some clarification. Individuals request open records. We are not required to authenticate responses to open records requests. That's not a part of the Open Records Act. They're also not required to produce anything that we do not have in our possession, even when individuals think we do. I'll give an example there, Ms. Merchant.
No, I agree with you. I don't need an example. But I guess all that would remain then is what Ms. Merchant is saying, that
you have records and that you haven't given
all she's after is authentication, and that hasn't been provided. But she thinks that a witness she
Never
has subpoenaed.
requested authentication, Your Honor, absent this subpoena. That
All right.
wasn't a request. The first time we saw anything about authentication was at the service of the subpoena.
Okay. All right. So, Ms. Merchant,
are you gonna?
Where does this stand then?
Judge, it's two things. First, that's how we have to get business record certificates, is we have to subpoena the witness. And if they want to avoid coming and testifying, they can submit a business records affidavit. We drew one up and submitted it with the subpoena. So I believe we followed the proper procedure to get these records certified. As far as that they've given us everything they have not. As far as the first bullet point, we do not have invoice number 22 or 25. It's not been attached to anybody's pleadings. It's not anywhere, any place.
Okay, let's start there. So, Ms. Monroe, is invoice 22 or 25 something that's in the possession of Fulton County?
One by one.
Not that we're aware of, Your Honor.
Fulton County doesn't have an invoice for Nathan Wade. That's the custodian of records. Do you have an invoice for some dude you just gave 30 grand to? Do you have any financial records for that? No, we don't have it. Fulton County doesn't have it. Well, that's weird because Ashley Merchant got the others. So somebody has it.
Who would typically retain custody of those kind of things, those invoices or reimbursement requests? Would that just stay with the district attorney, or would Fulton County have all those?
The district attorney, and we'll follow up with our client, but it's our understanding that they provided the records they do have. I'm not sure what and R25 may not be a part of those records, but we can confirm that all that we have in our possession has been provided.
Unbelievable. So was somebody deleting the records? Like, somebody has some of these invoices because Ashley Merchant has several of them. So did somebody delete them? Are they not? Somebody didn't enter in the $30,000 monthly payments to this dude? This whole county, man, is a disaster.
And Judge, I've been asking for invoice 22 since September.
It's an invoice.
Okay. All right. And
it's an invoice. It's not anything like wild. Like, you're not asking for like the source code of your gas chromatography DUI analysis machine. Like, okay, you're going to fight over that. That's fine. But this is an invoice. She's got the other ones.
And Ms. Merchant, you were talking about, you said that the next three bullets were invoices for Mr. Bradley, contracts for Ms. Cross and Mr. Floyd. I guess turning to Ms. Monroe or Ms. Miller, are those also things that you're saying are not in the possession of Fulton County and only in the possession of the district attorney?
We're not trying to delineate between the district attorney and Fulton County. What we're saying is our clients provide us those records, the records that they have in their possession. There are presumptions about what should exist and what we should have in our possession. But just because individuals think they exist doesn't mean we necessarily have them in our possession for whatever reason.
Where are they?
Okay.
Does Fani have
Understood.
them?
Do you have them though?
No, not that we're aware of. And we have conferred with our client, and it is our understanding that everything that is in the client's possession has been provided.
Okay, so as far as I can tell, they do not have invoices. They have missing invoices. Okay, so Fulton County has lost an invoice for probably $20,000 to $30,000. Several of them. They can't find them.
Okay, so then that sounds like a follow-up question to their client, the district attorney's office, if they've been under subpoena for these same documents. But for now, the person subpoenaed is saying, or the entity subpoenaed is saying they don't have them. And unless counsel has a reason to show that they do, I think that's usually the end of it.
Ms. Cross appeared today, I believe, under contract. She's been submitting invoices. So, I mean, maybe they just come and testify as to how they have people under contract.
It's not that it doesn't exist. It's where is it? And have you subpoenaed the right entity or person?
Well, they have represented that they represent the district attorney. They even filed this motion to Quash saying they represent the district attorney.
This is ridiculous.
So
that's a very good point. So, Ms. Miller, Ms. Monroe, regardless of whether they're down the hall or across the street, if you are the entity where legal process has to go in order to serve the district attorney's office for production,
thank you.
How does that get you out of complying with the subpoena?
Right. We don't have it.
Your Honor, I'm so sorry. I don't mean to interrupt, and you can tell me to wait, and I will gladly do it. But insofar as we're talking about a subsequent contract for me, there is none in existence.
You get invoiced?
Okay.
Do you get
and
invoiced?
that's again, I keep hearing two different things. Either it exists or it doesn't exist, or someone has or doesn't have it. And kind of keep flipping back and forth between the two. And I'm trying to nail this down.
Apologies, Your Honor, for being unclear. Anything that we have in our possession that our client has in its possession, we have provided.
Okay.
There are assumptions about.
And this is, and she said this like 5 times, right? This is the standard prosecutor's language, okay? And they get away with this crap all the time. It's not even in just, state court, federal courts all over the place. But they say, we do not have possession of it and we can't find it and we're not obligated to go find it. And a lot of the case law supports them because it's like, well, the government's big. They have a lot of records and you're not entitled to make them go, track down all your stuff. But that is the different here. They have asserted that they represent Fani, and she's the person who's paying these people, whether it's a contract or not. We're talking about invoices. Anna, did you get paid?
Things that we have that are inaccurate because we've provided everything that either our office or the district attorney's office has.
Okay.
We're not trying to hide it.
No, that makes it clearer. So that you're saying that you would be, either you or collectively the DA's office would be responsible for providing these if you have them. And your understanding, just again, going back to the first bullet point, is that a invoice 22 or 25 has already been provided.
It may not have been provided, Your Honor, but if it hasn't been provided, it's because we don't have it in our possession. And when I say we, I'm saying the collective we, the district attorney's office.
Okay. Thank you. I think that's where I've been getting held up. Okay, but that's something you plan to follow up and confirm.
We will definitely follow up we have followed up numerous times with our client, but we will again for the purposes of.
They don't have $30,000
And as for the remaining items, contracts with Floyd, Cross, Bradley, is it the same thing that collectively you either think they've been provided or they don't exist?
Correct.
All right, Ms. Merchant.
We would just ask that they come obviously they can't do a business record certificate to say something doesn't exist. So I think it just makes sense then for me to not even ask for the business record certificate and ask them to just bring the certified documents, whatever they have, and testify on the 15th of this. Seems the only way to figure out what exists, doesn't exist, existed. I mean, invoice 22 has been paid. Invoice 25 has been paid.
Yeah.
Sure.
So someone has them.
Yeah, they're there or not. Crazy. Total incompetence. This is your government at work, by the way.
Okay, so I think ultimately it's like if there is something that you were being.
We don't often get to see it, right? This is something that is just being exposed, thankfully, in the middle of a criminal defense case. But had Ashley Merchant and her team not cracked this whole thing open, we would have never known any of this, okay? So shout out to Ashley Merchant. We cannot say that enough. All of this would have just been covered right up, and they would have just prosecuted along the way without anybody being any wiser at all.
Compelled to provide that does not exist or that has already been provided, and you can confirm that, then there's no obligation on your part to do anything further with the subpoena. However, it appears that in order to complete the evidentiary record, counsel needs at least some kind of testimony establishing the absence of a record or testimony authenticating records that have already been produced. And so if there's not going to be a certification to that effect, then there would need to be live testimony to that end. And so I don't think that an outright quashal is what happens with
go get the records
this motion or Fulton County.
Understood, Your Honor.
If there are other particulars that come up between now and Thursday, and you think you want more guidance or clarification, we can take it up.
Wow.
Thank you.
Okay.
Wow.
All right. Thank you all for joining us. Of course. Thank you.
Thank you. Have a good afternoon.
Wow. All right. So.
All right. Are there any other? I think we got through them all.
Yeah. No, Judge.
Anything else? Anyone else here who anticipated needing to address before Ms. Cross? Anything else?
Just a minor logistical point, Your Honor.
Yes, ma'am.
At any evidentiary hearing on Thursday, we would ask the court's permission to have a witness who's out of state testify remotely.
All right. Can you identify that witness?
Yes, it's the district attorney's father. His name is Mr. Floyd. He's in California.
All right, Ms. Merchant, is that something you're prepared to address at the moment?
If I can speak with him ahead of time, then I'm very likely to agree and not object to that and waive the notice.
They're getting Papa Fani to come in. He's a little unwell, so he's going to zoom in.
That we're permitted. But I just asked that I be allowed to speak to him ahead of time.
Okay, and Ms. Cross, is that solely for logistical reasons, or are there other, perhaps, medical concerns or other things that might compel remote testimony?
There are medical conditions, as I'm aware, none that affect the witness's ability to appear. But I believe there are some medical issues involved in addition to the out-of-state travel.
Okay, understood. I'll let you and Ms. Merchant take that up, and you
Thank
can
you.
let me know if that's something we still need to address before Thursday. As I mentioned, we've set aside all day Thursday. We've also set aside Friday, and we'll see if further time is required, depending on where the hearing takes us. In terms of logistics,
we got 2 full days.
No, a number of defense counsel have adopted the motion and joined it. Many of them are with us today. Ms. Merchant, have you had any conversations with counsel as to how you would proceed. Are they all planning to have you as their flag bearer? Are they all, when it comes to arguments, when it comes to direct or cross-examination?
I haven't had that specific question. I think that I'm probably going to be leading it, but I'm not sure. They filed a little bit different motions. Some of them had some different allegations. So
Yeah,
they may
we
have
want
their
you
own
to
issues.
lead it, Ashley.
As far as that, I did have one housekeeping matter though. Mr. Wade has not accepted service of our subpoena. The state raised that in their motion. Since he has a lawyer, I reached out to Mr. Evans, his lawyer, and asked him if he would accept it on his behalf. I didn't want my process server to have to follow him around. I hate having lawyers do that, but I just need some direction if he's going to accept the subpoena or if I need to have him staked out.
So
Go
there's
get
an
him.
alternative means of services. They're not, you can serve as counsel of record.
Yes,
Go get him,
I can serve
Ashley.
it. Well, in civil, I can. They raised an objection in Ms. Cross's motion to the service that I'd sent by certified mail, and he keeps refusing that service. So the alternative would be for me to either serve his attorney with permission of his attorney, Mr. Evans, or
I don't even know if it requires his permission. I don't have the statute handy at the moment. Maybe someone else can pull it up, but it's about 2 code sections following Quashel. So 241325, if you can pull that for me.
I mean, if he's accepting service, then it would obviously be easy, but I don't know if he is.
But what I'm curious about here is if it matters whether his attorney is accepting or if you just send it to a certified address, if that's sufficient.
The law says if we send it certified, that is sufficient. I know that the statute actually did print that statute out. He's refusing service though. So I think that they could raise that because they raised it in their brief. They're raising that it wasn't.
Well, if the lead counsel in this case is refusing service, I'll entertain a motion for a continuance until he can be properly served.
Okay, thank you, Judge.
Your Honor, before we go, can I correct something?
Sure.
I misspoke when I said that Mr. Floyd had medical problems that might prevent his travel. That's not the case. It's just his location in California that would require the remote participation with the court's permission.
All right. Thank you, Ms. Cross.
Good to correct the record.
Anything else, Ms. Merchant, you said is housekeeping?
Mr. Gillen said he is going to be presenting a summary witness, but that's it as far as just for housekeeping. A summary witness, hopefully to summarize all of the financial records, so it's a little bit easier.
Okay.
Thank you.
All right. So again, I would ask you to confer with counsel to confirm whether everyone's expecting to do their own argument. If so, we're going to have some time limits. If other people are presenting their own witnesses, I haven't heard of any because I haven't gotten any other motions to quash. And whether folks are combining their ability to cross. I think if they've joined the motion, they have the right to present their own evidence. I think I can limit argument to some extent. And again, I can very much, as we get through cross, if a question's already been asked, I don't really care who's asked it. And we'll streamline things that way. I think someone from the gallery wanted to be heard.
Yes, from the gallery, Your Honor.
If you could identify yourself for the record.
Yes, Steve Sadow, counsel for President Trump.
Oh.
When you're finished, I have a unrelated matter I'd like to take up with the court outside everyone else's involvement.
And is this ex parte?
It would be ex parte, yes, sir.
All right. Anything else?
Interesting. Okay, so that was Trump's lawyer, Steve Sadow. And he was in court behind the bar as a lawyer, right? Sitting back there watching all this stuff. Says, Judge, I need to talk to you after the fact, ex parte, which means I'm not talking to the prosecutor. I just need to address something with you, Judge, alone, right? Separate and apart from anybody. So Trump's attorney was there watching this whole thing unfold, and they're wrapping up.
If not, we'll be off the record. Thank you.
All right. That's it. All rise. Oh, get up. All right. All rise. All right. Judge is here. Judge is leaving. All right. All right. Woo! We're off the record, man. That was a motions hearing out of Fulton County to disqualify Fani Willis. Of course, the hearing is coming up. That was a subpoena hearing to see if they could quash those subpoenas so that Fani did not have to testify. And she still may not. She still may, squeak out of this thing, but we'll see because they're bringing in Terrence Bradley, and Bradley is going to blow the lid off this whole thing when he comes in to testify. And it is going to be spicy. I want to say that Ashley Merchant is an absolute phenom. Oh my goodness. That was some incredible lawyering. She had a full handle on the whole proceeding from beginning to end. Okay, every one of those other lawyers who came back out, they just had small little clients, one at a time. They had one issue to hop up on, and she beat them all up badly, right? And they embarrassed themselves. They even came out full of their ego and their bravado, and they said, there's no reason for me to be here. And she said this and this and this. And didn't you call him? And didn't you tell him not to testify? That's a problem. My goodness, that was one of the most insane hearings I think we've ever covered here. And what happens on Thursday is probably going to be even more insane. So I hope that you join us as we cover it, my friends. We're planning on covering that thing top to bottom. So hopefully you subscribe and join us as we do. We're covering all the Trump cases here. We're covering what's happening in Florida classified documents case, the January 6th saga. We're covering it all. The ballot removal nonsense from the Supreme Court, the immunity decision that's going up to the Supreme Court probably soon, and more. And so hopefully you join us as we continue to expose all of this. They're exposing themselves, and they just keep digging themselves deeper into a hole. And this couldn't be better for the entire lawfare defense, right? All of the Trump litigation is now, I think, going to be in many ways over, I would say, subsumed, right? Or overshadowed, rather, by this case. Fani Willis is going to become like the lightning rod, right? The albatross that hangs around the neck of the lawfare prosecutors, because this is symbolic of everything else that we're seeing. They are just so bad at their jobs that they turn this into a giant explosion for all of us to see. But this same pattern, right, this same type of corruption is evident throughout our government and throughout the Trump prosecutions, and she's just making it easy for us to see. It's all now crystallizing right in front of our eyes, and this hearing is not going to go well for them. In fact, a part of me thinks that if it wasn't Fani Willis and Nathan Wade, two people who think that they, I think, are untouchable, given their act and their penchant for going on cruises once a month for multiple months on end, they have so much, I think, ego and bravado that they'll probably try to survive this thing. But I would not be surprised at all, if we wake up and one of them has resigned, honestly, because this is going to be bad. It's going to be so bad, and they are not going to want the spillover to impact, the rest of their cases. And think about this, my friends. Like, yes, this is about the Trump case, but the reason district attorneys are so insulated and so protected is because what happens if this impacts all of their cases? Okay, what happens if right now we're focused on Trump and Michael Roman and Ashley Merchant and everything that they've been able to expose. But what if there's other corruption? And what if they have to start dumping out thousands of criminal cases, right? If the entire Fulton County office is now slowly crumbling, and think about all of that capital that's been invested into thousands of criminal cases that are all working their way through the system right now. Okay, what if Fani Willis had some other corruption that gets exposed? And so when things like this happen, when the institution is under threat by justice, actual justice, you start to see corruption compound on corruption. You start to see people lying by filing affidavits. You see other people making phone calls like that Gabe dude. Hey, just want to remind you that you could be in trouble. Okay, they all start to circle the wagons to protect themselves. And this is like a free-for-all. Defense attorneys in Fulton County, defense attorneys in Atlanta, it's like they just went to Disneyland, okay? Or maybe, when Disneyland used to be something that people wanted to go to before they were talking about what they're talking about. It's like an exciting event because this is so much energy strapped around such an important case that they're going to be making probably their careers off this case. And so we cannot wait to cover this. It is going to be so much fun. I hope that you subscribe, my friends. Thank you for also checking out some of the other things that we work on here. Links in the description below. I want to invite you to come over to our lodge, the Watcher Lodge, this week. We have a great, presuming that we're not covering the hearing on Friday, we're going to have Jason Campbell, Zen Wellness, come in. So go register for this event at watcherlodge.com. It is going to be a great event. He's awesome. He's a black belt. He's a musician. He's going to teach us how to Zen ourselves out. Somebody should probably invite Fani to that. They're going to need some Zen after this all goes down. But my friends, we're going to be here continuing to cover. Thank you for joining us as we do, and we'll look forward to seeing you right back here on the next one. All right, my friends. Well, that is it for us on the day. My goodness. We had a very big showing today. Thank you, my friends, everybody who's joining us today. This case is wild, and you made it a great day to join us. So we covered Fani in two different filings, not only her 66-page supplemental, but also the full hearing where, man, that was just a disaster for them. But now, my friends, it's time to hear from you. Let's see what you have to say about this. We also have our members-only community where we're talking about a lot of the election stuff and a bunch of stuff that we can't get to here over at watchingthewatchers.locals.com. We're going to wrap it up as soon as we're done here. Go over there for our after party. We do streams in the morning. We do Saturday streams. We're covering election stuff. We've got a private Telegram group for our members, and we'd love to see you over there. But let's see who is here and joining us on this beautiful day. First one is from Dachshund over on the Locals. Good to see you, Dachshund. Sharing this one. Says, good afternoon, Rob. Missed the morning stream, but I get to catch this one while I head out to Tippin, Ohio from Morris, Illinois. Well, that's great. Have a very safe drive there, Dachshund. Thanks for joining us. Hopefully you catch up on the morning stream. It was a good one. We talked about how Kamala Harris is ready to lead. She's going to save America. We got this one from Generic Derek. Says, Rob, did you check if they used the governmental travel booking mentioned by a membo last week? I didn't check. I didn't see on that one. But when they put in G in there, apparently that's a government ticket. So in other words, the allegation was that Nathan Wade was using government discounts as well. Hey, we got notice. News was made today. Robert, Trump's brief was just filed with SCOTUS. Woo. Okay, so we'll probably cover that one tomorrow. And I'm glad they timed it, after our show, after the show already got started. Thank you, Knittin' Kitten. Thanks for sending that dono in, and thanks for being a member over on the YouTubes. Grateful to have you. Spud says, hey, Rob, can I get a shout out for my dad? Heck yeah. He hit the big 9-0. Shout out to Papa Spuds in the house. Whoo, happy birthday to Papa Spuds, the big 9-0. Happy birthday. Wow, amazing. So shout out to Spud's dad. We got John McGarvey, who's sharing this one. John McGarvey shared this one from the Babylon Bee. Okay, first female referee throws a flag on the play, but won't say what's wrong. We're all familiar with these female referees, aren't we? Yeah. Throw a flag on the play, then won't tell you what happened. Okay. Gloria is bringing in, what's up, Gloria? Bringing in 5 new membos as a membo. Bringing in Glenn C. Bourne's coming in. Scott P's coming in. Tom F's coming in. Tom G. also coming in, courtesy of Gloria B. Good to see you, Gloria. Thanks for bringing in new membos in the house. Hey, what's up, Pritchie? Pritchie is sharing English pounds on the day. Wow. Says, hey, from the UK, love your show, so we'll support. Thank you, Pritchie. Says, hope SCOTUS does the right thing and reverses the ballot and upholds immunity. The world needs Trump back. You're telling us, man, we're here in the United States and we're like, gosh, if you even feel that way in the UK, man, you can't vote in our elections though, can you? Well, maybe if you come across the border illegally, then you can. We'll have to see you there. Maybe make your way over here. We'll have you vote. Just kidding, feds, relax. This one, oh, that was from, okay, thank you for that one, Pritchie. Very good to see you. We got Glenn. What's up, Glenn? Bringing in new membos. Barbara Joe. We got Squatch Girl is coming in. We got Bobby B. Halatala Chick. Arnett S. All coming in courtesy of Glenn Croy, who's a membo, bringing in 5 new membos. Amazing. What's up? This one from Glocky says, this is from Zero Hedge. While Fani is fleecing taxpayers, 1,200 homes have been taken over in Atlanta by squatters. Oh my gosh, I was just talking to my friend about this. He knows everything about real estate, and he was telling me about this. He said, like, all the realtors are talking about this in Atlanta. And there's apparently, like, cleanup crews that are coming and, like, removing the squatters. Atlanta's in big trouble, man. I don't know what's going on over there. What's up, John? John McGarvey is bringing in 5 new membos. As a membo is bringing in Maureen. Look at this fancy title on this. How'd you do that? Raphael V. The Lonely Kakapow is here. SJ is joining us along with Freed in the house, courtesy of our friend John McGarvey, bringing in the newest of membos. We also got Chubby Stubbies here. Says, sadly, I'm not even remotely shocked to hear about Big Fanny spreading the taint across all of Fulton County, Georgia. But things are pretty tainted in Georgia. Yeah, and there were a lot of smelling comments today, wasn't there? Smelling. Like how things smell. Weird. Glocky says the binder was sold to the highest bidder. What does this say? Special counsel unable to determine the location of a top secret briefing book that Biden misplaced while he was in the Hamptons. What? Wow, that sounds pretty bad. Thanks, Glocky. Red One is bringing in new membos. Red One, as a membo, is bringing in Stephen K., Tom H., Brian R.'s coming in. Ulysses is here, along with Gulicio in the house, brought in courtesy of our friend Red One. Very good to see you, everybody. Welcome aboard. And when you join up on YouTube, don't forget to grab the private members only Telegram link. On YouTube, if you go to the community tab section, scroll all the way down, you're going to find a private members only Telegram link, and that's where we'll see you for the members only after party. Hey, what's up? Ryan Patrick's in the house. Good to see you, Ryan. Thanks for stopping by, and thanks for reminding everybody to smash that like button. You know, I forget to do it. It's important. I appreciate it. Thank you, Ryan. Hopefully you're doing well, my man. Thanks for stopping by. We got Alice E. says, okay, I listened to the Supreme Court hearing. What's up, Alice? Says they kept asking about why the president wasn't mentioned in the 14th Amendment. Yeah, even actually Ketanji asked about that. Says, it seems to me that if voters vote for an insurrectionist in a majority, it would mean that they support the insurrection. Yeah, the framers, as I understand it, thought that revolutions were healthy for a nation. Ben Franklin thought that there should be one every 10 years. Is it possible this was the framers' line of thinking? Yes, absolutely, I think so, Alice. If the people say that we want you to lead us, then apparently they don't think that you're an insurrectionist, right? They just think that you're a valid leader of the nation. Like, that's all. And I think that's exactly right. It's like, hey, you know, if the people want to vote for this person, they can vote for this person. And that's the power of, you know, democracy. So I absolutely agree. Like, why would you disqualify that? The people have the final say. The people can override that veto. So I totally agree. Good to see you, Alice. Great comment. This one from T. Lewis says, hello, Rob. This just dropped a few minutes ago. Oh, my goodness. So right after we went live, they filed their SCOTUS brief. We'll cover that one tomorrow, my friend. So we'll definitely be back for that. Thanks for the link, T. Lewis. Save us some time over here. Generic says, they both got matching Trump mugshot tattoos like their favorite rappers. Oh, my gosh. Could you imagine? I hope Judge McAfee says, okay, let's see the tattoo. All right. Somebody should subpoena that tattoo. Ashley Merchant should subpoena that tattoo. Judge, we make a motion for the court to see Fani's Fanny. Yep, there it is. $78. There it is. There's Trump's mugshot on Fani's Fanny. Could be. We got First Amendment says, can Fani and Wade be disbarred for this if she's found guilty? Well, she hasn't been charged with anything yet, but yeah, I would say so. Yeah. If you are, you know, embezzling funds in any way, the state bar is going to have a big problem with that. We got this from John McGarvey. Says, have you been studying? Do you get this meme? The lack of DX is disturbing. I find the lack of DX disturbing. What does DX stand for? I think we're talking about ham radio, right? So actually, yeah, I have been studying. In fact, I have a new app that I've been studying for my ham radio. It's actually a great app. It's $3.99. You got to pay for it, but it's great. Ham Study, amateur radio license exam. Here's a question. When the control operator is not the station licensee, who is responsible for the proper operation of the station? I know this one. It's answer D. Okay, answer D. I'm pretty sure it's answer D. Okay, this is my ham radio study guide. Pretty sure that one's answer D. Let's see if I got it right. Boom, got it. That's your boy. Boom, got it. All right. Yeah, I've been studying, man. I'm ready to get my ham license. Yeah, it's distance, DX. Yeah, there you go. Distance. Okay, there you go. All right. So we're getting into some ham radio stuff at watcherlodge.com. We're going to get our ham licenses. Yeah, it's a write-off. All right. Fred says, hey, what's up, Fred? Fred says, I literally haven't been on vacation in 11 years. That's kind of how I feel. Yeah, I was like, when's the last time I've been on vacation? I don't know. I go to like different events and stuff, but like a cruise? It's been never. Okay. So yeah, it's been a long time. So they go like once a month. It's good to be a county attorney who's got enough money to, you know, grift off of a Trump prosecution. What's up, Knox? Says, happy Monday, all. Sounds like they need some poopery down in Georgia. You're right about that. I don't know. They need like, probably like a couple dump trucks of poopery right in Fani's office. Andrea, what's up, Andrea C? I think my Telegram just completely froze. Yeah, look at that. Telegram is totally frozen. Well, there you go. Okay, have to figure out what to do about that now. But okay, so that's totally frozen. Okay, let me reboot this. because that is now definitely dead. Hopefully the rest of the computer is not locking up as we speak right now. So that media viewers busted. Are we still streaming? Are we still, broadcasting? I feel like my computer screen, everything is locking down right now. So, are we still broadcasting? It looks like we are. Let me see if I can figure out something else to do here. Everything just locked up. Yeah. Very strange. Okay. So I can't really click anything or see anything. So let me see if I can get Telegram right here, and we'll just finish out the donos right here. Let's see what we got here. Because I can't see, my computer's not working. We're going to let that thing crash out, and then we'll wrap this up. So we got some new donos that have come in. And here were a bunch of them. Okay, so Andrea C. wrote, do you see how nervous all the representatives of those who were subpoenaed were? Not as nervous as the record keeper lady. She kept pushing the "we don't have those records," LOL. Yeah, that's from Andrea. Andrea C. You can't see the texts. But yes, they were very, very nervous. They were not happy with how this proceeding went down. It was bad. It was bad. Is my voice desyncing now? All right. So that was from Andrea C. Andrea, thank you for that one. Dolphin Fan is the man is bringing in Leon L., Michael Pack, Roger Wood, Pinochet's Helicopter Tours is coming in. We got Cheryl B. also all coming in courtesy of Dolphin Fan is the man. Thank you, Dolphin. Linda Anderson is in the house. Linda sending in a nice dono. Thank you, Linda, for that one. Hey, Pritchie says, sorry, I'm an hour later joining the stream. Fani for jail and dismissal of charges, immunity upheld, and ballot reversed. Then Trump for 4 years. Then Trump for 4 years. We got Tiger Shark says, purple drank for the boys. Sugar, water, and purple. Purple drank for the boys. Sugar, water, and purple. Jennifer says, Rob, you are the master of ceremonies with this political circus. Many thanks. Is my voice going out of sync now too? Computer's just freezing down. I don't know what the heck's going on. Jennifer, Rob, you're the master of ceremonies with this political circus. Many thanks. Thank you, Jennifer. I appreciate you on that one. Knox is here, a defense attorney in Texas, says, sigh, I wonder how much old Nathan is wishing he had just steered clear of that big Fani. Yeah, way too much. Way too much Fani for any one man, and now he's dealing with the consequences. Rocky says, man, do I love cameras in the courtroom. Cheers to court cameras. Cheers to court cameras and court camera angles. Says, yes, in the interest of justice, John Allen says, yes, in the interest of justice, all courtrooms should have podium height cameras. We were talking about, of course, the court proceeding that we had today. We also have Glocky McGlock says, I watched the entire hearing today and I'm impressed with this judge. He takes notes. He's attentive. He asks law-based questions. He isn't worried about calling out the shenanigans. If Trump ends up going to trial, I think he's lucked out in getting a judge like this one. What do you think? Agree. That's all we care about. Yeah, it's all we care about is just a fair proceeding with fair, approaches to both sides. Hey, Dane says, can you do more streams like this? And he has 2 O's next to each other. Can you do more streams like this with 2 O's next to each other? Catherine R says, Catherine says, please pray for my dog. So we're praying for Catherine's puppy out there. Says, Pickles, she has a vet visit tomorrow. I rushed her in today, but they think she'll be okay until tomorrow. We're praying for Pickles and a speedy recovery. Better have my money says, okay, this says, B better have my money. Says, Fani better have my money. It's a nice comment from Fani better have my money. Hey, Stephanie Womax. Whoa, Stephanie W. has been a member for 24 months. Amazing. 2 years. That's a lot. That's a long time, Stephanie. Thank you so much for supporting us for 2 years. You know what we've been through here? Oh my gosh. Says to impeach Fani Willis, support Bob Smith in Western Georgia. Support Bob Smith from Western Georgia. Knox says dignitary services, security detail. I guess my takeaway is the big question. Who the heck does Fani think she is? Every day, ADAs and the defense run the gamut to get to the courthouse down here, and no one I know has security. Not even DA Kim. Yeah, and she's Fani. She's the biggest Fani in Fulton County, so she gets whatever she wants. Obviously. She's Fani. Good to see you, Knox. Hey, B better have my money, says Fani better have my money. Cindy says he doesn't understand that it has nothing to do with Roman's case. It has to do with prosecuting for profit and charging every Tom, Dick, and Harry to drag the case out to make more money so they can have more cruises and more vacation time with Cindy Banks. Good to see you, Cindy. Cindy says, so sorry, I have macular degeneration and I can see better when I'm typing. Oh, I see. Oh, I didn't think you were yelling. So Cindy wrote in all caps and then she said, I'm not yelling at you. No, it's okay. Hey, Cindy, thank you. Jennifer says, Mr. Banks has become very fidgety in his seat. Yeah, he had a good poker face there for a while. He was like, Your Honor, there's no reason I should be a part of this case. I know nothing about anything. I have nothing of value to add. And she's like, well, you called the dude and told him not to testify. He's like, it's a good point. Forgot about that. See you Thursday. All right, Jennifer, we got BH Williams says, why are there so many posts with pics of the Wicked Witch of the West? I was sick all Sunday and you're bringing back my nausea. Someone get me some Zofran, stat, sublingual. Good to have in your hand on a survival kit. From BH Williams. Why are there so many posts of the Wicked Witch of the West? Good question. Hope you're feeling better, BH. Rocky says, I called him on a personal level, quote. Says, ha, beautiful, right? I called him just as a fraternity brother. We're not really talking about anything other than fraternity stuff. Chubby says, he's a bad dancer. He's doing the salsa right into a charge of witness intimidation. A lousy frat bro, too. Yeah, he just converted into real time. Oops, as on a personal level, right? This one from Larry says, what an absolute Georgia Bulldog. Ashley Merchant should be our next AG. Ashley Merchant is a monster, okay, in the good way, right? Like a beast. She is formidable. She is very good. She's like a pit bull. She's like a Georgia Bulldog. Just like you said, Larry. Totally agree. Pinecone brought in Mama Catania Mama Italia is coming in as a membo, courtesy of Pinecone. Derek W says, okay, we need a bubble wrap meme ASAP. Yeah. Somebody get Terrence Bradley and put him in bubble wrap. Thank you for that, Derek. This one from John Smith says invoices 1/8 and 22 and 25 were paid, but no records. Yeah, and they're like, we don't have it. We're like, well, go get it. No, we're not going to because we don't have it. Well, that's your job to go get it. Glocky says, breaking just a couple minutes ago, the hearings are going to be lit. Yeah, they are going to be lit. Oh, wow, look at this. So Glocky shared this story. It says Trump plans to attend Georgia hearing on misconduct allegations against prosecutors. Oh my gosh, this is going to be so great. Thursday is going to be like a free-for-all. Just cancel everything, okay? Just cancel everything. Fred says Ashley Merchant's hourly fees are going up. They should. She's amazing. Good to see you, Fred. Fred Pedamonte in the house with his rascally dog, Johnny. We got this one from Jeremiah says, every show I am grateful for watching the watchers. Jeremiah, thank you. I'm grateful for you. Says so many people don't know what they're missing. This hearing was more exciting than the Super Bowl. I couldn't agree with you more. I mean, I absolutely... Today's hearing was like, I was shocked by some of what we heard. That guy, Gabe, shows up, says he's got nothing to say, and then has everything to say, apparently. Hey, Makina, Realty Maui. What's up, Makina? No question, but thank you for sending in the nice super chat. Appreciate you very much, Makina. We had this one from Gerald. What's up, Gerald? Over on Rumble, shout out to our Rumble friends, says, imagine if the 90s had Robert Govea's shows instead of Judge Judy. The world would be in a much different place. Well, that's what it's going to be. Okay, the 2020s and 30s and 40s and 50s, we're going to take over #1 place and wake up more of this country. And it's going to be great. We're going to save America together, my friends. Looking forward to doing it with you. Gerald, thank you for saying that. It's going to be a long road ahead, a beautiful road ahead. but we're making some good progress, Gerald. Thanks for saying that. Knox says, I would love to have criminal cases in this county. I would challenge everything, like when the crime lab gets exposed. 100% Knox. I was thinking about that. We had a crime lab kerfuffle here in Arizona back in 2012 with DUIs. And it reminds me of like a lower version of this. Like what's happening in Fulton County is crazy. Like defense attorneys in this whole country are going, what? Why did that happen in my county? I got all my cases dismissed. So we're all having a lot of fun. Makina, Realty Maui says, ask the county financial software provider to find the invoice on their server. Yeah, just go check your CRM. Do you guys use QuickBooks? Go check in there. Just click the accounts tab. Go look back there. But they're like, no, we don't want to show you it. Maybe it's a big fat dono. Maybe those are not $30,000 months, but like $50,000 months or something weird. Probably not, but we'll see. Hey, MT Coiner, been a member for 5 months. Thank you, MT Coiner. 5 months, says thank you for the coverage. I very much appreciate you. Thanks for being here. And hey, Knox is also wishing Spud's dad a happy birthday. Happy birthday to Spud's dad. Knox Bierman says happy birthday to Spud's dad. Spud says Wade should have used the AAA discount. It is usually close to the government rate. Is it cheaper than government fees? And Brian's here. Welcome aboard, Brian, our newest shout-out supporter. Don't forget to grab the Telegram link on YouTube, the members-only link. Raider Gaines says, do you think that frat and sorority members shouldn't be allowed to practice law or at least disclose that they are members? Same with jury members. No, I don't think that. I mean, frat and sorority, it's an interesting question, but frat and sorority members, I don't think it really has anything to do with the law. You disqualify a bunch of people. But lawyers are otherwise prohibited from making ridiculous, phone calls like that. It's like ethical. Right? You shouldn't like kind of impliedly threaten people, which maybe he was doing if he's from Fanny's office, I don't know. But good to see you, Raider Gaines. Thanks for that. Rocky says, Rob, I protest today's chat of juvenile humor. Were there boob jokes today? Says boobs and smells and hot dogs. I've never seen, here we go, such a jejune chat. That's our word of the day. What does that word mean? Simplistic, basic, is that the word? There were some boob comments today. I saw them. I did see them. This one from Angel says, Rob, almost as many viewers as CNN. Probably. I don't know. Probably. Who's watching their shows over there? Is anybody? Good to see you, Angel. Thanks for that. And Swade's Lounge says, breaking, Trump is going to be attending the Fani misconduct hearing, which is just incredible. So amazing. We've also got this one from Rob over from the UK, submitting this one in pounds. Says, could Ashley submit a subpoena for bank records where the invoices were paid? Was thinking that they may have misplaced invoices 22 and 25, but I doubt that the bank would make the same mistake with their record keeping. Yeah, that's a great point, right? So obviously somebody got the money. So can you see the deposits in Nathan Wade's bank account? Like you can see the invoices. So from the invoices that he does have, where did those get dropped? What bank account did those go into? And then here you would just say, let's get those same, those same invoices. So you could correlate them, right? Where did they land and how do they match? And so that came over from Rob. Thank you for sending that one in, Rob. And thank you to Donut Mind Me and John Allen for clipping away for us and saving our butts now that the computer has frozen up. Let me see if there's anything I can do to salvage this, to see if we can say hello to our friends on the X platform and come back to locals for our after party. But I think this thing is pretty well and good locked up. So, my friends, we're going to leave it there. We are going to... my whole computer is like frozen and locked up, so I can't touch really anything. So we're going to miss saying hello to our friends on X, and we're going to miss our friends on our locals after party. But locals, we're going to come back in the morning, and we're going to catch up on both threads on our members only stream in the morning. So I apologize, but the whole computer wigged out. So I'm going to have to just reboot the whole thing. But we are going to come back, my friends, here tomorrow. Now, on our members only stream, we're going to catch up in the morning on our after party comments because everything's locked and I'm going to have to end it. So we're going to come back and finish that in the morning. But we are also going to be here as a regular show, as per usual, to get into it all again. And tomorrow's going to be a pretty big day because we're going to have Trump and the SCOTUS filing, and we're going to see what else is percolating. And so, if I missed you, we'll catch you back up on here tomorrow. My friends, don't forget to check out all the various links that we have in the description. Check out watchyourlodge.com. We got a bunch of fun events coming up. We have a great community building over there. Check out robertgovea.com to get the PDFs, the show notes, and check out watchingthewatchers.locals.com for our members only community. We talk election and more stuff that we can't get to here. We'd love to see you there. We also want to thank our mods and our meme smiths. You know who you are. Today, I want to give special shout outs to John Allen and our friend Donut, who are clipping away for us. Mod in the fort down, nice and orderly. And K-Bean. Thank you, K-Bean. But my friends, that is it for us on the night. Thanks for bearing with me while we're dealing with that frozen screen and what's going on. We're going to be back tomorrow with a freshly rebooted computer. And so we'll see you back then tomorrow. But we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.